En jy Felicity se presentation of Good morning. My name is Dion Reuters. I'm the senior prosecutor attached to the National Prosecuting Authority over here in the Western Cape. We were supposed to start 8:45, but we are challenged as far as technology is concerned. We are experts with our mouths in speaking about the maintenance legislation, but we come second when it comes to electronics. In case anyone over here is an electronic expert, please help us because Mr. Opperman and I have been busy for the last half an hour to sort things out. But somehow it fails our intelligence. We just want to show us how clever we actually are. So I will leave that to one side so that we can at least have a start to our program. I'm glad to see there's such a lot of people that are coming early, so we will be able to start within the next few minutes. Just as a start, I would like to just introduce some of the VIPs that are in the room today with no specific preference. Um, they are very important people amongst us. Number one is my colleagues that came all the way from Sears and they're sitting up here. Please stand. I want everybody to see these people asked a colleague of mine in Worcester if they could come, and then they uh, they asked if they can somehow get somebody to assist them. They then decided to, on their own, make a way to get here, whether it is getting a bus or whatever, and that's how they got here. These people went out of their way and got their own bus to get here. Natasha, I think you need to introduce the other most important person before we get there. Sorry? I will make sure that there is food for you just for all the trouble that you've gone through and for all the trouble that you've gone through to get your own bus to get here. I will make sure that there is food for you. Just to say, these people got up early this morning. When I was still in bed, they were already on their way here. So because of that, I will make it up to you for all the trouble that you've gone through. Natasha?
Morning, everybody. There's quite a bit of people today, Nick. Yeah, we are growing every month. So, well done. Okay. This morning I am for a pivar. Yeah, I don't know what the English word for it is. Forward. And I decided I want to ask Advocate Reuters to introduce one specific person. But before I do that, I just want the Cape Town ladies who are applicants or complainants in a Cape Town court just to raise your hand for me, please. Don't be shy. Okay, so all of you. On a while back, some of you might know that I've been haunting specific people in the province, trying to get a meeting, to discuss issues. And I really felt like, I'm hitting my head against the wall here. These things are not happening. My emails remain unanswered, and it really frustrated me. So I was very privileged. In the week, I received a message, and the message said, I will phone you after 2:15 to talk about your matter. And I looked at the number and I thought, maybe this person is confused because he can't really help me with my matter. But anyway, I responded to say thank you. And so was wragtig at about whatever that time that he said he will phone. My phone rang, but the call didn't come through. And I phoned back. And this person said, hello, Mrs. Struble. And I said, Mr. Isaacs. So I want to welcome Mr. Rodney Isaacs, who's the regional head for the Western Cape. And I just want to tell the ladies that are here. Mr. Isaacs only started here in February. He's a man that wants to fix things. I heard it from him. Myself and Felicity had the privilege of meeting him in this week, and he's really, really committed. So he wants to work with us. So please do not kill him, okay? Because I thought, if you can just listen to us, we want to help, we want to work together. When I met him, before I said that, his response was, we need to work together. So that is, for me, it was confirmation that we are heading in the right direction. So as much as I understand, we have frustrations and there's lots of things that we need to fix. Both parties are aware of this. But we can work together in a proper and a better way. We don't have to agree, but we will fix it. And I can promise you, in my heart, I sense that he wants to do this. So please give him a chance. And Mr. Isaacs, if you can just briefly stand up so that everybody can see where they need to throw the stone. So,
Welcome, Mr. Isaacs. I thought you could come and say a word or two. Are you okay? All right. Okay. Yeah, okay. Mr. Isaacs did indicate that he just wanted to sit and listen. But I want to tell you, he's the regional lead for the Department of Justice in the Western Cape. He was in the Northern Cape. I had the privilege of being in the Northern Cape last month, and I did training over there with some of the public prosecutors in the Northern Cape in Kimberley at the DPP office. And I was accused of stealing Mr. Isaacs. I didn't even know that Mr. Isaacs would be coming here. But the Northern Cape is poorer without him, and all of them want him back. So I know the abilities, and I've seen what he's done, and I can see how the Northern Cape is mourning their loss, which is our gain. So hopefully within the next few months, it will become more and more clear of what he is capable. We've got other distinguished guests today. That will be joining us from the National Credit Bureaus. They are sitting at the back next to Loyi and Annika. They're in the middle between them, and my wife is protecting them from behind. That is Kubani as well as Marina. Kubani and Marina can just stand so that people can see. They will maybe doing a presentation on the National Credit Bureau, and they will enlighten us as far as how the Credit Bureau is working and how they can assist us with some of the challenges that we have in South Africa. Thank you for coming. These two people came all the way from Johannesburg, also at own cost. NPA don't have money to pay for all of it, so they must pay themselves. So they are also one of the people that got themselves on a plane to be able to address us and to show us what we can do as far as credit listing and all of the other things in terms of Section 26, as well as Section 31(4) of the Maintenance Act is all about. But we will get to that a little bit later on. I will ask Loyi if you can maybe introduce them, since you are having contact with them and know such a lot about them. So please, last month we had, it was still in this month, Kobani as well as Loyi did a presentation to the National Prosecuting Authority in Pretoria, and they enlightened us as far as how the National Credit Act have a provision that somehow makes it that whenever people go and apply for credit, they need to also make sure that a maintenance order is listed as one of the reasons why people will be granted credit or will not be granted credit. But that provision is not working in the South African system, and they will show us how we can make it work. Around 11:05, they will do their presentation. I just also would like to introduce some of our other guests that are over here. I only see one of my colleagues sitting over here, the maintenance officers, Ms. Roxanne Jansen. Can you just stand so that people see who you are? So Ms. Roxanne Jansen is the maintenance officer that is assigned to the Belleville Court. On Facebook, on Felicity's group, there were some beautiful things that have been said of her over the last few months. She's newly appointed over there, but she is really showing what she's capable of in Belleville. And it shows, as I said in the beginning of this year, we've got these golden nuggets of maintenance officers that are willing to work and show what they can do. And if we have more of them, then we can do even more. So because of that, we will do something else later on. And let me just quickly say that I didn't plan this, but next month or Monday is Women's Month. For Women's Month, there will be no female presenters, or no male presenters of the NPA Community Dialogue. We will have an all-women team that will be congregating over here on the 20th of August. And the 20th of August, they will be addressing us, and we will hear from women how they feel about maintenance in the system in South Africa. So all the presenters will be female. I myself will not be speaking. I wanted to say I'm going to sit and do the technology, but the technology doesn't even work today. So I will just be over here to listen and then participate in that way to the conversation and dialogues. We've got a special MC. You will see here that the 20th of August that already indicated that there's a possibility, but she's still speaking to God. God is guiding her, and will tell her whether she will be ready for us on that day to facilitate the session. There's some distinguished guests that will speak on that day, the 20th of August, same venue. So those of you that would like to make a note of it, 20th of August, we will have the community dialogue over here. I will sit over there where Eugene is sitting. Eugene will not be here. Eugene will be all the way in Spain, but he's the only one that we will be able to connect that's male. And we will try and connect with him in Spain and show where he's walking. He wants to walk 400 kilometers. I'm not crazy like that, but we let him do it. So he will be walking all the way from I don't know what place to another place in Spain. And hopefully maybe he'll get us some money over there in dollars and euros and pounds. So hopefully he'll bring some pounds and euros back to South Africa for our community dialogues. The program for today, we will start off with a discussion on the Law Commission paper and where it is right now. Some of us participated in the process. The discussion paper 157, Project 100B of the SA Law Commission. That is what Mr. Opperman as well as myself will present first on. And then from there onwards, we will give Felicity an opportunity where she will do a women's dialogue, and we will have some chairs over here where we will then give Felicity an opportunity then to conduct a women's dialogue on financial abuse. Then we will give the National Credit Bureau an opportunity to then do their presentation on the provisions as far as blacklisting is concerned in Section 26 and Section 31(4) of the Maintenance Act. I got a request that we also look at the Z versus Z case of the Supreme Court of Appeal. I am always over here. My face has always been seen, and I've been asked if there is time, I will ask my wife to do a presentation on the Z versus Z Supreme Court case, as well as give an analysis of 18-year-olds, what happened in the case of 18-year-olds in the justice system, if we have time. If we don't have time, based on our schedule, then we will let it stand over till September, because in August month, our program is already full. So then we will do a presentation on 18-year-olds and the current position based on the Supreme Court of Appeal case, what we are supposed to do. She's got some good advice that she will give to some of you on how to deal with it, how to compile your opposing affidavit and all of those things. So then we will be able to deal with the position of 18-year-olds in the maintenance system when we get to it. I will be doing a presentation then later on the Fisher case as far as the position when it comes to school fees, because sometimes divorce orders are being made and the divorce orders say that the respondent, the father, must pay the maintenance, must pay the school fees. Then you just don't care about it. The Schools Act says both parties are equally liable. So despite the divorce order, the Schools Act will still blacklist even the mother, even though the divorce order says no, she's not supposed to be liable by the father. So I will explain that process a little bit later on. And then Eugene will do a presentation on spousal, the different types of spousal maintenance and how you can then deal with cases where you are in need of financial assistance from the other party in spousal maintenance matters. Okay, so before we then proceed with the program, I will give over to my colleague, Eugene Ottoman.
Good morning, ladies and gentlemen. Can everybody hear me there at the back? Am I loud enough? I'm used to screaming at magistrates, maintenance officers in court. So yes, welcome, a special welcome to our online viewers. I see that there's quite a lot of people linking in and also on our Facebook page, www.childmaintenance.org.za. That is where all you guys get your bookings from. We do have trouble, a little bit of technology constraints. Like I said, I'm a legal practitioner. I'm still BC, before computers. So I'm trying with this. Dion, I think there's somewhere there might be a camera at the back showing this screen there, and that might be the conflict, but we'll sort that out. In the meanwhile, the slides will be made available on the website for you guys so that you can see what we were talking about. The people online could actually see it because we're running it from a PC. So I've got the main screen in front of me, and unless you guys stand behind me, it's only me that can have access to the slideshow. So and just in brief, yes, like Dion alluded to, there were a couple of us that gave our submissions to the South African Law Reform Commission a while ago, and that was on amendments or proposed amendments to the Maintenance Act. It was a 3-day workshop where they had people from the financial institutions, they had legal practitioners, they had magistrates, they had advocates. So there was a lot of people, a lot of input to scrutinize and to see how changes could be made on the Maintenance Act. It was called, let me just start off by saying that the aim of that was to identify the loopholes. So this was the aim, this was the task of the South African Law Commission, to identify the loopholes pertaining to the challenges of implementing the system or the Act, the Maintenance Act, and also to make the Act more user-friendly, if that would at all be possible, and preventing, the biggest one for me is preventing the abuse of the system by maintenance defaulters. So that was their task that they had to do. So what now? So we had the 3-day workshop. So many people ask me, but Eugene, you know what now? What next? What's going on? So it all started off with the department or the Minister of Justice, or should I say Minister Against Justice at that stage, wanting to give some input to find out how can the loopholes be overcome. And it all started with a pre-investigation paper. And then there was an issue paper. And this is the discussion paper or the paper that we gave our comments on. It was proposals that they put forth. It was a panel of experts led by Professor Linky de Jong. to scrutinize and to get input from public, from other stakeholders, in order to formalize some changes to the Maintenance Act. What would happen now is after the 3-day workshop and the input and the submissions of all these stakeholders, they've been compiling all of this. Now, I've been in contact with most of the panel, Advocate Mugane, Stefanie Erasmus from the NPA, Prof. Linky as well, just to find out, how can we assist further, as well as people from the financial industry. How can we assist further? Because the process from now on would be the issue paper that was obviously then done. Now there will be a couple of discussion papers. The wheels of government is turning slowly. So there will be a couple of discussion papers, and that would contain essential information on the investigation that was done, and then the proposals being put forth for implementation. And only after that, a final report would be compiled together with draft legislation, and that would be submitted to Parliament. And then the parliamentary process would start, where the bill would be introduced to Cabinet, and at the end of the day, it might be signed into law. So this is not a quick fix, guys. This is not going to happen overnight. It is a lengthy process. If one look at history, we would see the 2014 Law Review Reform Commission, the issue paper or discussion paper that they had then, it took 2 years for them to implement that. So do not expect miracles. You know what? They do work miracles, but the impossible takes just a little bit longer. So I can't have the screens now. The screens will be on for the online viewers only at this stage, up until we get the projectors running. I think they're behind me. I'm going to start off with what they discussed in Chapter 2. So I'm going to give you a brief discussion or explanation of what was discussed. These slides will all be made available to you guys sitting here in person attending. So they made a couple of recommendations, and they invited people online to engage into conversation and in discussion on how this could be made better. And Chapter 2 dealt with mediation, the more inquisitorial role by the officials, and interim maintenance orders. In short, what it said there was, and that the Commission recognized, was that, generally speaking, mediation could be regarded as a better alternative to court proceedings. Now, that is quite obvious. If you do not need to go to court and be exposed to a judicial system, and you can have it as a mediation, that could work. Mediation is not a quick fix. It's not the end all. It is one of the tools in the toolbox of the maintenance officer and the judiciary in order to expedite maintenance mediations. Specific under Project 100B, there was proposals put forth in another act called the Family Dispute Resolution Bill that was published. So that would be dealt, the details of the mediators, the qualifications of the mediators, the training that they need, that would all be discussed in that discussion paper. So that's also a parallel process that runs with the amendments of the Maintenance Act. It is foreseen that in terms of the exceptions clause in the bill, the proposed maintenance amendment bill, that most maintenance matters will be exempted from mandatory mediation. There were loads of discussions. Should it be mandatory? Should it be made mandatory, especially in terms of Section 41 of the High Court legislation, where you need first to approach a mediator before you could go to trial. So the question about the mandatory issue of mediation were discussed intensively, and I'll get to that later on. The Commission recognised that some form of mediation is already taking place in maintenance courts. All of you guys that have been to the maintenance court doing a Section 6 inquiry, the informal inquiry at the maintenance officer's office, there is a formal, informal part of unstructured mediating taking place, where you get the two peoples in front of the office, they submit their documents, and then there's interactive negotiation between the maintenance officer and the two parties to discuss, to come to some kind of agreement. If an agreement is done there and could be reached there, hunky-dory, Bob's your uncle, and a consent order could be made. Not a problem, not a problem. That would alleviate and would take the burden off the courts of going through the whole process of a formal Section 10 inquiry where a presiding officer needs to decide what amount should be allocated towards maintenance. So there is some scope for that. It is also said that maintenance officers at this stage are the only people doing these type of mediations. It is not being delegated to outside parties like community mediators or private mediators as well. And they build in their system and in their proposals, they build in, and I'll get to that in a while, they build in a structure where it allows for external mediators to become involved, obviously at a cost, as well as community mediators. The Commission also recommends that maintenance officers should be obliged to provide mediation services to parties at the investigation stage. So mediation is not an option if you go for a Section 10, because that is done before presiding officer. The magistrate would decide on that amount. Then the time for mediation, you know what, the nice talking, the putting in cotton balls and protecting people are done. So it's only used in the investigation phase. The Commission also recognised that where necessary, a maintenance matter should be treated as an urgent matter. In all honesty, all maintenance matters are considered urgent. You cannot wait for 9 months for your matter to be attended. It is ridiculous. All matters pertaining to children, and they are protected in terms of Section 28 of the Constitution. To use Advocate Reiter's words, Jesus could only go 40 days without food. Why should children do the same? Why should the matters be postponed? So there's merit, it's valid that all maintenance matters should be treated as urgent. The Commission also recognised that the duties of the maintenance officers and the maintenance should be extended. And I'll explain to that in a while. The Commission then also realised that any delay could jeopardise the well-being of the maintenance recipient. Now that is as obvious as mud. Any postponement, any remand, any unnecessary layering on of additional requirements in terms of the Act would seriously jeopardize the recipient of the maintenance, and it could be detrimental to the children. The Commission, very strangely, and there was quite a lengthy discussion on that, recommended that maintenance courts should be empowered to hear ex parte applications and make interim orders as to provide immediate relief. And in a certain degree, I do agree with that. I feel it is necessary that an ex parte application could be brought, but it could also have some serious problems because interim orders or ex parte applications are only judged on paperwork. There's no evidence that's being laid. And that might be problematic because one clever attorney might come up and say, but you know what, there's the ade alteram partem rule, which basically says that, you know what, you should hear the other side of the party, the other party's voice should also be heard. So there might be constraints with regarding to that. And linked with that, in order to on an ex parte basis to issue an interim order without the responding being there to voice his opinion or to submit his documents might be problematic on the long run. We are in discussions with the Law Reform Commission to come up with certain structures how that could be overcome. The Commission feels very strongly that once a maintenance matter is lodged and the proof of the income of a person that's legally liable to maintain and that is able to do so, the matter should be taken to court the same day or at the earliest possible chance they get afterwards, so that an interim order could be made. That was the proposal by the South African Law Reform Commission. If there's no order and there's no proof of income, and it is established that that person is liable to maintain the children, so that it is the father, paternity might not be in dispute, or even if it is in dispute, that the matter should be referred for investigation. Then you would have the normal Regulation 3, people coming to the maintenance officer's office, and there would be some form of negotiation between the parties. You know what, are you the father? Yes, I am the father. Sign here that you are the father. Or no, I dispute that, because that they use as an excuse. I'm not the father. So the matter gets postponed again for DNA tests. And then the dad rocks up at the next event and he says, but you know what, I didn't have money to pay for the DNA tests. So I need an extension of another 6 months in order to get money for that. That's delays. That's unnecessary, and it unnecessarily prejudices the mother. A very interesting one that the Commission also feels strongly about is that maintenance matters should be permitted to be brought outside of court hours. So that does not mean that you can go to the court at 11 o'clock at night because you feel like it. Surely on an urgent basis, the proposed regulations would and acts, articles, sections would allow for that to be brought outside of court hours. During a recent meeting that we had with Mr. Isaac, sorry, I'm going to put you on the spot again. A very nice, a very well meeting, very good meeting, where we discussed that, and this was discussed at the Law Reform Commission's workshop as well, where Saturday courts could be implemented. In the 2014, years back, in the 2014 Law Reform Commission paper, the discussion paper, it was recommended then already that the Commission should investigate a system where Saturday courts could be brought in. And that was just ignored, or it was not giving much attention to. And Mr. Isaac and myself and Felicity had a discussion regarding that. And we proposed that we set forth a proposal to the Department of Justice so that a system could be implemented where Saturday courts could be used. That would probably be from the morning 8:30 to 1:30. So it would not be a full day. Now, there might be certain constraints. I'm not going to bore you with that. That would be in a detailed proposal between all the stakeholders at this stage. But there is a possibility. Subsequently, after our meeting, I also discussed the matter or the issue or the proposal with some magistrates. I've also discussed it with some maintenance officers. I've discussed it with some the court investigators, the court clerks, as well as the office managers, and they were all very positive. Maintenance is always seen as the orphan child of the Department of Justice, and it should not be like that. It should not be like that. Getting people that are passionate, people that want to change, people that want to effect change, and they can do it on a Saturday to assist people, because most of the moms cannot afford to take yet another day off work to go to sit in line at a maintenance court, only to be turned away and come back at a later stage. And at the end of the year, when she needs to go on a well-deserved holiday, all her holiday leave is used up. We do not want to do that. Like I said, that the magistrates, Commission also proposed that the magistrate must also be authorized to deal with the maintenance matters on an urgent basis and to play a more inquisitorial role. It was quite strange why they put in the inquisitorial role, because there is case law very clearly stating that the magistrate should not take an adversarial approach. They should be an inquisitorial once dealing with the Section 10 inquiries. So if you in front of the court, the magistrate needs to be involved. He needs to come down to the arena and he needs to take hands with a maintenance officer and the defendant and the respondent in order to resolve the matter. So he cannot just sit there with his Batman robe and listen to the people, evidence being presented like in a normal civil case. He should play an inquisitorial role and become involved in this whole process. It was actually brought in their proposal in the Law Reform Commission's papers on how it could be changed to bring in a certain section under Section 4, where it says that the maintenance officer is then responsible for ensuring that all relevant evidence from both parties are placed before court, even though the parties might be represented, in order for the court to come to a just conclusion. Section 10 was also amended by bringing in Section 10.7, that is their proposal, that the responsibility of adducing evidence at any inquiry not only rests on the parties, but also on the maintenance officer and the magistrate. So it's been codified. It's not only in law, it's not only in case law, it's been codified. It is contained in the Act. This is what they propose. What they also done is they extended the area of jurisdiction to include that you can bring the application or a complaint within the area of jurisdiction in which a person to be maintained is living, or in whose care that person to be maintained is, where he resides, carries on business, or is employed with a view to inquiring into the financial position of those parties. So they have extended the jurisdiction part thereof, which is quite welcome. I want to bring in Section 3B that applications could be brought outside of ordinary hours or on a day that is not normally an ordinary court day. Now we come with the inclusion of Section 4. And I want to read that out for you because that's quite important. That pertains to the mediators. There was loads of discussion. Probably the most of the time that we engaged with the Law Reform Commission was spent on the usage of mediators. Will it work? Can it work? The overall feeling was that mediation will come in. Judge Tulare is a very avid proposer of mediation being brought into mainstream maintenance with good right as well. It says that after investigation, the application of the complainant, the maintenance officer must advise the parties to attempt to resolve the matter through mediation. And this mediation could be provided by, one, a private mediator, whose costs will then be shared equally between the parties. It could be referred to, if such a mediator is available, to a community-based mediator. And if there are costs involved, that those costs be shared amongst both parties. And then lastly, the maintenance officer dealing with a matter could be tasked to do that, to do the mediation. Now, to a certain degree, and then the provision here was that the mediation should be concluded within 30 days. And I'm glad that they've put that in. But I don't like the following: unless the mediator provides the parties with a reasonable explanation in writing for a delay. So my problem that I proposed to the Law Reform Commission was that, you know what, Dad pitches up, he says, you know what, I don't have money for a mediator. It needs to be concluded within 30 days, but no, he doesn't have money. So what would the mediator do? The private mediator or even the community-based mediator would be placed in a position where he can inform the court in writing that there might be a further extension needed. What would happen now? it would be concluded and it would just be postponed for another period of time. Mom would go without maintenance for another period of time. So our proposal was to say that they could extend that for a period of 30 days, but there should be a time limit. There should be a cap on that to say, but you know what, after 60 days or 45 days, whatever they choose or decide on, the matter, if no mediation was done whatsoever for whatever reason, the matter must go to court. Otherwise, it would just be putting up another layer and another layer and another layer on an already overburdened system. Very positive was that now service of documents, which we all have a massive problem with, is that electronic mail, facsimile, short messaging services, or other known social media used by the person who needs to be served could be used to serve documents. Absolutely brilliant provision. And that is in line with the Domestic Violence Amendment Act as well. That dealt with Section 2, or Chapter 2. Chapter 3 dealt with the determination of maintenance awards. How is maintenance calculated? And we all know that in terms of Section 15.3 of the Maintenance Act, it currently provides that there's a duty of care, a duty of support, rests upon both parents pro rata according to their means. But you know what, the Act is not very clear on that. What does that mean? For the layperson in the street, they do not know what that means. Also bear in mind, the Maintenance Act also deals with spousal maintenance, and now you have got Section 7.2 of the Divorce Act, which also provides that a list of factors could be taken into account when considering spousal maintenance, and I'll deal with that in a separate section later this afternoon. At this stage, there is no clear formula or guidelines as presided as on precisely how to award maintenance, how to calculate maintenance, both of the child and or the mother in case of spousal maintenance. And legal officers, attorneys like me, court officers, magistrates, all have their own way and approach to calculate the amount of maintenance awards. And that becomes problematic. There was quite a lengthy discussion on case law, on how we do that. In the Western Cape, we're very prone to use the acute versus acute principle. We allocate shares for one share for a minor child and 2 shares for an adult in order to get a baseline to work from, to say that, you know what, we all work on a uniform basis. There is no such thing as 50-50, although some of the magistrates do believe it is still 50-50. You know what, and it's not wrong, because then they contravene Section 15.3, where it says it should be pro rata, and they do not understand that. They do not, and that speaks to training of the judiciary as well. So they are busy investigating what system could be used, and that might take some doing. I think, personally, I think that there would be quite a number of discussion papers and proposals being put forth in the months and the weeks to come on how that could be done. Very wisely, because this process might take a while, and the working out and the calculation of child maintenance and or spousal maintenance could be an issue that could be dragged on, and some research needs to be done, and it could be changed quite often to adapt by the South African landscape. The Commission felt that the Minister should be empowered to publish guidelines under the regulations of the Act that deal specifically with this. And this is welcomed, because then the regulations do not need to go through this whole lengthy process of putting it forth to Cabinet and the discussions and the investigations and the research papers and everything that needs to be done. So that is quite welcome. Moving on, they proposed that you include that in Section 44 of the Act. They wanted to bring it in line with the Namibian Act. Now, the Namibian Act is very similar. Namibia uses much of our legal expertise on their way of structuring the acts and legislation. And the Commission felt that they had to include more factors in Section 15.3, where it says, it needs to be done pro rata. They wanted to bring in more factors that the court specifically should look at. Those include the age of the child, because obviously a child of 18 years eats like electrolytes. You know what? They eat more than most of the adults. They are, they should be considered to be adults. And that's why the CUT system, one portion might not work. The number of children or beneficiaries to maintenance is claimed from should be taken account. The educational, financial, and developmental needs of the child should also be taken account. If you've got a bright spark kiddie wanting to study medicine, obviously you need to take into account that there might be need to be provision for tertiary education. The direct and indirect cost incurred by the complainant in providing care for the child or the beneficiary should also be taken into account. Brilliant. Mom stays at home. She takes the kiddie to work, to school, to preschool. She takes them to ballet classes or whatever the case might be. But there's no value put on that. That should be taken into account as well. Very important. Chapter 4. Chapter 4 of the Commission paper that we discussed was the recognition of other forms of payment of maintenance awards. Unfortunately, we do not work with gold nuggets. But we could. In terms of the proposed Chapter 4, it says the maintenance order, the definition of maintenance order will be extended to include payment in kind, either by way of supplying specific goods, which might be livestock, or providing a service or services, and or payment of sums of money, including the periodical payment thereof. This was quite welcome. Because Dad coming from the Transkei or living close to the Transkei might have 27,248 cattle that he could sell. So that's welcomed. And that is considered payment in kind. That is absolutely welcome. Even if the father cannot pay the 500 Rand a month, there would be, in terms of this proposed legislation, a way that he could contribute, even if it's just by giving food. If he has a mini fruit and veg spaza shop, that he could actually give fruit and vegetables, and that could be linked to a monetary value as a maintenance contribution. So that was absolutely welcomed. They want to propose a change in Section 16 so that any court making an order for payment in kind, now that is considered not the body check. It's not the payment in kind. That's what most of you guys, and especially Advocate Riel Reiters, is thinking about. It's not that. Payment in kind referring to cattle or whatever the case might be. There should be an order in the alternative for payment in the sum of money equivalent to that payment of kind. So put a value on the groceries that he needs to buy, or the value on the cattle that he needs to sell. We discussed the powers of arrest by investigating officers. And it was quite a heavy discussion, and it was led by Advocate Muganu. And the Commission proposed that there should be no amendments. The power of arrest should solely rest with our, I struggle to use the word competent, SAPS. But yes, the powers of arrest should rest with the SAPS. And the biggest reason for that, and I totally agree with that, is because if we were to open it to investigating officers, then attorneys like me can retire, because I would sue the Minister of Police for wrongful arrests every single day. And that was why they probably excluded that as well. Coming to locus standi, Bjorn, you're going to do locus standi. Yes.
Okay, the position as far as locus standi is concerned, it's just a Latin word. I don't know why we still have to use these Latin words, but it just means in the place of. Locus, location, standing in the place of. Staan in die plek van iemand anders. So, locus standi is one thing that our courts are struggling with a lot, especially when the person turns 18 years old, and that's what we discussed at Edom during ad nauseum at the Law Commission. And luckily I was there every single day of the commission with Eugene, Felicity. My wife was also there every day, and Natasha, and we made sure that we got our views across. Because the 18-year-olds, whenever we deal with 18-year-olds in the justice system, as soon as they turn 18 and 1 second, then the maintenance officers all over South Africa, not just in the Western Cape, wants to get rid of them. Now they must come and apply on their own. Luckily for us, we've got Z versus Z that was decided 21st of July in the High Court in Gauteng, where it now, not the High Court in Gauteng, sorry, in the Supreme Court of Appeal in Bloemfontein, where Judge Piet Meyer made that clear. Whenever the person turns 18, it doesn't mean that in that specific case that he must go and stand in court himself, because at 18 years old, and I'm glad if you have an opportunity to read the Z versus Z case, please just read paragraph 16, 17, 18, and 19. That's the most important. If you read those 3 paragraphs, then you'll get the gist of the Z versus Z case, where Judge Piet Meyer made the position quite clear as far as 18-year-olds is concerned. So now, whenever a child turns 18, it doesn't mean that that person will have to come and apply on him or herself, because that is what's happening in South Africa. As soon as the child turns 18, then it is expected that that child must come to court himself and apply for himself, while he's got absolutely no idea why he's eating so much. He's got absolutely no idea why the electricity bill is like that. But he has to sit next to the respondent, which might be the father or his mother, in case he's living with his father. And then he has to apply for maintenance, being now just turning 18. In terms of Section 17 of the Children's Act, 38 of 2005, it says that whenever a child turns the age of 18, that child is being deemed to be an adult. So when they turn the age of 18, they are now being dragged into the maintenance courts, where they will then have to come and fend for themselves and have to explain why they need maintenance. Luckily for us, in the Law Commission paper, they dealt with it. And to our benefit now is the fact that children can do it in terms of the Z versus Z case, while we are waiting for this specific provision in the Maintenance Amendment Act to one day come in operation, because it's going to take some time. We've finished the Law Commission process now. The Law Commission is going to complete the amendment bill. The amendment bill is going to be introduced into Parliament. Once it's introduced into Parliament, then Parliament's Justice Portfolio Committee will send out invites where we can participate again, and then we can say how we feel about some of these sections. And even individuals like you can go to Parliament and say, listen, I've got an 18-year-old child. This is what I'm going through. This is the struggle I have. Please make sure that the Chapter 5 provision as far as locus standi is implemented, because at the end of the day, my child can benefit from it, especially if there is not a good relationship between the child with his father figure, because sometimes the father figure is not involved at all. They don't call, they don't do anything, but they want a parenting plan. They go and they want to have this parenting plan. As soon as it comes to the implementation of it, then they are nowhere to be found. It's not your turn to come and fetch the child this weekend. Now, where do you want to go to the nightclubs and all of it? Then they want to tell the mothers those things. Then they don't think of any of that. And mothers will not go to court and enforce, in terms of Section 34 and 35 of the Children's Act, enforce their rights to have the parenting plan enforced as far as it's your weekend, you must come and fetch the child. They don't do that because they're too scared to somehow bring any change in the relationship between the father and the child. So therefore, they will let me rather keep quiet. If it comes December at least, then I've got one day that he was there. And that's what they unfortunately do. So we spoke about this, and Professor Lientjie de Jong is quite in favor of this specific provision, where also in the definition of the Maintenance Amendment Bill, applicant is now going to be extended to also include a person having a relationship, a mother, father, aunt, or anyone like that. Because what happened, and I've got one case where I'm struggling with this specific concept. As soon as the mother passed away and the child is living with the mother's mother, the grandmother, then there needs to be a care and guardianship application being done in the High Court. What if she's living in Vredendal, that is 400 kilometers from here? Then she will, the poor granny that is living in Glen William or in Claver will have to come to the Cape Town High Court in order to get that order to be a care and guardianship so that she can then qualify for maintenance. And I've got some of these grannies that call me and ask me, please, this needs to change. So luckily in the Maintenance Amendment Act, there's a provision where the definition of applicant will be changed now to include the uncle, aunt, or whoever else is taking care of their child, or as the definition says, anyone that shows a material interest in the child's life. So in a case where the neighbors see that everyone passed away and he knows these people since 40 years ago, and now it's only the children living there, and he shows a material interest, there's nothing that stops him. He doesn't have to go to the High Court and apply for a care and guardianship order. I don't see my colleague over here, Peter Higo's not here. Peter Higo did something this week in the Piketberg Court that is it's not been done before, and I would like him to one day come and explain how he did it, specifically dealing with grandmothers that is applying to take over that maintenance role where the mother or father passed away. In most cases, we are forced to do care and guardianship orders whenever we are dealing with it. So the court, or in the Law Commission, we spoke about the different cases that are involved in care and guardianship, and then we looked at the Bursey versus Bursey case. We had a look at Butcher versus Butcher, and what happened in those cases. Bursey said that mothers have locus standi. It's also discussed in the Z versus Z Constitutional Court, the High Court of Appeal case that was decided 21 July last month. No, it's still July, this month, a few weeks ago, where it was discussed, the Z versus Z case. In it, they discussed Bursey versus Bursey, they discussed Butcher versus Butcher, and what happened in all of these cases, because there are these conflicting views. And I would like you to understand this from Bursey versus Bursey as well as Butcher. In Bursey versus Bursey, the Supreme Court of Appeal in 1999 said that mothers can apply for maintenance on behalf of their adult children. Then, and unfortunately, it happened in March 1999, just before the Maintenance Act was promulgated on 26 November 1999. So because of that, the Maintenance Act wasn't the way the Maintenance Act is currently. Fast forward 10 years later to 2009. 2009, we got Butcher as well as Smith versus Smith and other cases. These cases overturned, even though there was a Supreme Court of Appeal decision saying that mothers will have locus standi to apply for maintenance on behalf of their adult children. It was changed by the Butcher case, where unfortunately the Western Cape Judge Glosner decided that in that specific case, that mothers do not have the right to apply. So now children were forced into the system. And because of all of this conflict, that is what gave rise to the fact that some courts will say, no, 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 if you're 18 and 1 second, then you must come and apply on your own. And the case is being closed for the mother, and the child will have to come to court. While in other jurisdictions, they will allow the mother to still take charge of that maintenance application, especially if the child is still at school and finishing matric, or in a case where the child is living in the same household. So we discussed that for 3 days, where we had a look at the provision as far as locus standi is concerned, and we had a look at the Namibian model, how the Namibia passed the Namibian Act regarding that position. And we are now trying to put it in line with the Namibian model, and also have the granny or the uncle or the aunt or whoever else wants to then stand in the case of a deceased family member, or in the case of child-headed households. Then for now it will be possible that anyone can stand in. So there is going to be the changes to the provision as far as Section 2, the relationship and who can apply. So that is one of the changes that will happen. The appointment, Chapter 6, the appointment of maintenance officers. There are 2 schools of thought. Luckily, one of the maintenance officers in South Africa that was commissioned to speak on behalf of the maintenance officers came and explained the position as far as there are 2 sets of maintenance officers. Section 4.1, maintenance officers that is appointed by the National Prosecuting Authority. Section 4.2, maintenance officers that is appointed by the Department of Justice. So because there are 2 different sets of maintenance officers, what sometimes happens is some of these cases fall to the crack, because NPA maintenance officer says, no, it's your work to do, I've got criminal work to do in the criminal courts. DOJ maintenance officer says, no, but I am stationed at Koekenaap, I need to go to Koekenaap, I can't be there. Part 26 of our NPA policy says that in a case where there is no maintenance officer, that court, the prosecutor is deemed a maintenance officer. And because of all of this, these cases fall through the cracks. And then there are some of these poor ladies that sit there the whole day, and then you'll get them on Felicity and Eugene's group and say that they've been there 18 times or 20 times, waiting for a maintenance officer or waiting for a maintenance officer. They stand in front of the prosecutor, and the prosecutor, they say, no, they're over there for maintenance. Then the prosecutor say to them, no, but there's no maintenance officer here. But Section 4.1 says a prosecutor is deemed a maintenance officer. So there's nothing in law that doesn't say that that prosecutor should take over, because the policy document of the NPA on it says in Part 26 that these prosecutors, in the absence of a maintenance officer, is deemed to be a maintenance officer. So we had a long discussion about what should happen, where it should happen, and how it should be legislated. There's one school of thought that says all of these maintenance officers should fall under the NPA, so that there's one set of maintenance officers that deal with these cases. Or there's the other school of thought that says have 2 sets of maintenance officers, the NPA maintenance officers as well as the Department of Justice's maintenance officers. My own view, I feel that the maintenance officers should be under one umbrella, and that is being under the NPA, and the NPA needs to be the one that is accountable for it. That's why the legal eagles, Mr. Roscoe, and all the other attorneys that's over here, what the interpretation of statute says is Section 4.1 is first, and they need to lead, and in hierarchy, they are the ones that will then have to take the lead. That's why Section 4.2 says that the NPA is tasked to create a dedicated pool of trained and experienced maintenance officers. They don't say in Section 4 that the NPA is tasked to only create a set of maintenance officers that are only forming part of the NPA. It says maintenance officers. Maintenance officers, whether it's a DOJ maintenance officer or an NPA maintenance officer, it's immaterial. It should be available to all of them. Luckily, the Minister of Justice will have to have these policy directions in place, So let's see what is going to happen within the next few months. There's a provision in the Maintenance Amendment Act where they'll say that the Chief Magistrate will swear the maintenance officers in, similar to what is happening currently when a prosecutor has to be sworn in by the Chief Magistrate or the magistrate at a specific court in order to fulfill those functionalities of what they need to then do. Chapter 8, dealing with future maintenance. We've always worked with future maintenance without a specific type of legislative framework. We only did future maintenance on Section 30, but on case law that was decided by Judge Ferdi Hartzenberg a few years ago, and that's how we dealt with future maintenance. For the first time in South Africa, future maintenance is going to be in a statutory framework. Before that, we relied on the case law in order to do future maintenance. Because if you're going to look at the Maintenance Act the way it is currently, there is no section that deals with future maintenance or say anything about future maintenance. The closest you get to it is Section 30, dealing with the attachment of debt, which is the attachment of retirement annuities or the attachment of pension funds. That can be done. But there's no legal framework to say, okay, but there's so much money over there, let's also make provision till the child is 18 or till whatever else the child wants to do in future. There's no such provision in our current maintenance legislation the way it is. So because of that, the Law Commission thought that it will be expedient and good that we now include in the Maintenance Amendment Act a provision that statutorily provide for future maintenance. So because of that, there will be an amendment to what a maintenance order is to also include a future maintenance order, because the way the future or the maintenance orders currently is, it just says in Section 1 of the Maintenance Act that a maintenance order is a payment of a sum of money, including the periodical payment of a sum of money. So in this specific case, now we're going to be adding also a maintenance order can also be livestock. So the example Eugene made, it's got a lot of chickens, then you can give some of those chickens so that we can slaughter them so that the child can eat. So those type of provisions is going to be brought into the Maintenance Amendment Act when the Amendment Act is promulgated or introduced into the Justice Portfolio Committee. I would love to see it happening before the end of this year. I don't think we're going to make it. I don't want to sound pessimistic, but I know how the Justice Portfolio Committee have worked. I've been part of it since 2000. I saw what happened to the Child Justice Bill B49 of 2000. It took 10 years to get the Child Justice Bill to Parliament. It took 8 years to take the Children's Act to Parliament. And all the other pieces of legislation, from bill to the initial promulgation, it usually takes anything between 4 to 8 years, if we're lucky. So hopefully this Amendment Act will follow the same pattern as what happened to the Domestic Violence Amendment Act. The Domestic Violence Amendment Act is so progressive because of the GBV stance, as well as the NSP's involvement in it. If it wasn't for the stance of government as far as GBV and the constitution of the NSP is concerned, we wouldn't have been so good in getting this Domestic Violence Amendment Act to even provide for an electronic portal where people can submit electronically an application. Hopefully the same will happen in this specific case with the Maintenance Act. But nobody in the presentations to the Portfolio Committee made a specific recommendation that these type of maintenance applications can be done electronically. Myself as well as my wife, I'm not sure if Felicity covered that in her presentation, but we need to get to a point where electronic submission of these maintenance orders can be done. Because a mother must stay out of work in order to get that specific piece of paper to a maintenance clerk to say, please process this. If you don't have your ID document or something is not there, then your application, then they want all the documents. If it is electronically, then they can start processing that, and whenever it comes to it, The same way with the Domestic Violence Act, the Domestic Violence Amendment Act. As soon as that lady start processing or putting it in the portal, then they start working on it. The same we should do with Maintenance Act, with the Maintenance Amendment Act. Why? Because Section 11(1), subsistence and travel allowance, as soon as she said that she stayed out of work and have to now pay whatever she needs to pay, a taxi fare getting there, all of those things, then the court manager will tell you, "Nee, ons bedoel nie daai goed, ons betaal nie vir dit nie." So that the courts all over South Africa do not want to pay Section 11(1) subsistence and travel allowance to a mother coming to court for that specific application. Even though it's legislated and there's a statutory provision dealing with it, they are still not going to pay for it. So if we can get it in electronically, then the lady don't have to stay out work, because the employer tell her, "Wat nog moeg van die elke keer wat jy hoef toe gaan. I'm getting tired of you every time being at court." And nobody see that. So if we want to somehow play an active role, those of you that would like to go to me to Parliament, that's where our next step is going to be. We go to Parliament and say, the maintenance officers are not giving us what we are supposed to be getting. Section 10(6) interim order, we don't get Section 10(6) interim orders. Section 11(1), that is statutory, that I must at least get my taxi fare paid, is not being paid. Come Parliament, help us to get these type of things in place. And that's where we're going to start. As soon as the bill is introduced into Parliament, that's where we are heading with it. So future maintenance will hopefully make it better for us. The Western Cape is the one province that are very progressive as far as this is concerned. There were a few cases that was decided in the Western Cape by our High Court, where we are promulgating and leading the way as far as future maintenance is concerned. Mageva versus Zozo, Nancy Soller versus Magistrate Weinberg, all of these cases come from the Western Cape dealing with future maintenance. And hopefully within the next few months, when the statutory provision is being included in the maintenance amendment bill, it's going to be clause 25A until it becomes Section 25A that will deal specifically with future maintenance, and the word future maintenance is even going to be used in Section 25A, subsection 2 of the Act. That's where it is. No, don't say just I'm reading from here. It's not that I know all of these things offline. It's just that I'm reading from here, so it's not that I'm so clever. It's just I have everything over here in front of me. And as far as the different sources or that can be attached, it will include pension fund annuities, gratuities, living annuities, and all of those things. Especially the Act is also now going to include a provision as far as the alter ego is concerned, but that's in trust. I will explain that a little bit later. Gina, how am I doing with time? 10 minutes, okay. All right, Chapter 9 deals with the recovery for future maintenance. So usually what happens in Section 26, when you apply for attachment of an asset, or you apply for the attachment of emoluments, or you apply for attachment of debt, what usually happens is when you apply, then you have to wait 4 months or 5 months, and then that time more and more interest or arrears accrued. Or the respondent find out, well, I'm in trouble, so now he starts making payments. Then you want to say, no, but I did pay, so stop this proceedings. The court will now have an option where they can somehow balance it out. Okay, you made those payments, but this is the amount that's still outstanding. Because what the respondents do is they will always try to then oppose the application for the attachment by saying, no, but I did pay, so why am I still over here? And because of that, the magistrates will usually give them an opportunity, but Ms. Maintenance Officer, then why do you still have this case? He is paying. So to make sure that doesn't happen, the Maintenance Amendment Act will do like a balance calculator. All right, you pay so, but this is what you still owe. We're still going to attach based on whatever the amount is, whether it's going to be Section 26, Section 27, attachment of assets, Section 28, attachment of emoluments, or Section 30, attachment of debt. Whatever it is, that will be done, and it will be calculated to recover whatever the outstanding amount is as far as the execution process is concerned. So there will be an amendment to section 27, 28, and to section 30, subsection 2C of the Maintenance Amendment Act dealing with all of that. There's no amendment changes that will be done as far as the consequences of defaulting on the maintenance obligations is concerned. So the section 26 procedure as well as the section 30 procedure as far as a defaulting action, all of that, the Law Commission is not proposing any changes. There will still be attachment, there will still be prosecution. Some made recommendations as far as that it can run concurrently, because one of the problems that we have is if the attachment is busy, then they don't want to do, the prosecutors don't want to do prosecution. They say, no, first finish whatever you're doing there. But there's nothing in law that says that it can't run concurrently. So while you're busy attaching, it's still a defaulting action. You can still prosecute. So all of those things are, there's no recommendation that the Law Commission made as far as Chapter 10 is concerned, but some of us did make recommendations that there should be a concurrent process that is being run as far as civil attachment as well as criminal prosecutions is concerned in Chapter 10. The choice of a remedy for civil execution and procedural matters, usually when you apply for after defaulting action, then you will do it in terms of section 26 of the Maintenance Act. Then you have a choice on your JTO6. You must now decide, all right, do you want to attach assets, section 27, do you want to attach emoluments, section 28, right, with section 16.2, or do you want to attach a debt in terms of section 30? You must tick over there a block. You have absolutely no idea what's emoluments. Never heard of the word, especially me, I'm Afrikaans, like my colleagues from CS. We only speak Afrikaans. Emoluments is two big words. We don't know the words that have more than 4 syllables in it. So now you deal with these type of cases. You must tick. The Law Commission says what we're going to do whenever we deal with these type of cases is we will leave that up to the experts, the maintenance officer and the maintenance investigator. Do your investigations and find out where is the money. Is there assets that can be attached, or is there emoluments that can be attached, or is there a retirement annuity that he never told you about when you were married, or something else that is hidden? Then you make that decision what to be attached. Don't leave it to the poor applicant that have absolutely no idea, or that have not seen the guy for 8 years and now all of a sudden I have to tick on the JTO6 which one to take. So because of that, the choice of remedy, they call it a basket of choices, will be left over to the maintenance officer or the maintenance investigator that will have to then make those decisions. So section 26.1 and section 26.2 are the two sections that will then be amended accordingly to then also make sure that it is put in line where the maintenance staff will make that decision. And there is a provision in section 26.2 that you can either do it where you work or where you reside. That's also in the Maintenance Amendment Act 9 of 2015. So it is included over here again to make it clear that you are not just limited to where you stay. If your workplace is closer and the boss don't want to give you any time off, then you can always arrange during your lunchtime to quickly run over and have your sandwich over there while you're busy fighting with the maintenance officers to get that type of J101 or J107 to be submitted to the court in those cases. And then the insolvency of a maintenance debtor, section 30. The Act is also going to make provisions for in a case where a person is insolvent, because what the respondents usually will do is they will come to court and say, ek het nie geld, ek is bankrupt verklaar, I'm insolvent. So the Act will provide in section 30 for the maintenance creditor to become a preferential creditor. They will stand first in line before, not before SARS, actually second, first SARS, need to give them credit, otherwise they're going to deal with us. First SARS, and after SARS, then you will be next in line. Tax, even the Bible says, give to Caesar, so we must do that. So let's give to them what belongs to them. After that, then maintenance is ranked second whenever we will be dealing with these type of cases. The chapter 12 of holding an inquiry in terms of section 6, that will stay the same way it is. Cost orders, the Law Commission do not want to have cost orders attached, especially against applicants that already are indigenous, struggling to get money. Now they have an extra responsibility in having to pay cost orders by the respondent, where the respondent say, if you're going to take me, if you oppose this, then I'm going to make a cost order against you. And the attorneys are vouchers for it. Sorry, Mr. Koki, I'm not saying attorneys, but the other attorneys, not some of the attorneys sitting here, but those attorneys are vouchers for these cost orders to be implemented, especially against the lady. And then she's scared, oh hell, I don't have money for this. That's why ladies don't want to do Section 25 appeals, because they hear High Court, I don't have advocate money and all of that. That's the reason why people are not going for it. And that's one thing that also the Law Commission felt, is to deal with although they deal with the reviews, they don't deal with the cost orders or the cost implications for Section 25 appeals to the High Court. But I will try and quickly get there. Tasks in Chapter 14, they deal with alter egos. Is my time up? I'm trying to rush now. Task is the alter ego. So what the respondents do is they hide their money in other accounts, because that's the way that they think they can get away from it. The Law Commission somehow picked up on it, and because of that, the Law Commission is going to make certain recommendations where tasks are being used as an alter ego. And what I like about the Law Commission paper, they speak about this alter ego right too, and they also look at the different case law that is dealing with it. So in Section 26.4, and in the definition, they will specifically deal with the position of task. And task is also included in Section 26.4, as well as in Section 16.1b and Section 16.2 of the Amendment Act, where it will be specifically dealing with the Section 26.4 enforcement, as well as the Section 27 attachment of assets, and Section 29 for the attachment of emolument attachment orders, Section 30, the attachment of debt orders. The review and appeal process, quickly, in terms of Chapter 15, the old or the current act that we deal with in Section 25 do not make provision for appeals. The new act will make provision for appeals, because Section 25, you can only appeal against an order made by a magistrate. You cannot appeal against a decision by the maintenance officer, where the maintenance officer do not employ Section 10.6 and get an interim order. So if you ask for an interim order, there was no recourse that you had, where you can say, but why are you not asking for Section 10.6 order that is legislated? So because of that, the review process will make it easier for some of the applicants then to apply for a review of the proceedings. So if Ms. Jansen do not want to give a Section 10.6 interim order, then they can go to court and then use the provisions of the Maintenance Amendment Act. In the meantime, we can use Section 5 of the Promotion of Access to Justice Act, the PAJA legislation. And in our maintenance group, we do discuss that specific provision. The living annuities is usually an asset on its own, and I think my colleagues will touch on it, an asset on its own that cannot be touched. So what the respondents do is, if they say, hey, I've got a big amount, then I'd rather put it in a living annuity, because the living annuity becomes the owner of it, not the respondent. He says, I don't know, it belongs to Santam now, go after Santam. And they hide behind Santam and all these big financial institutions that got senior counsel that can deal with it. The Maintenance Amendment Act is now going to somehow allow us to go after piercing the corporate veil and get to those respondents that hide their money in living annuities. We will still get to it in terms of the provision as soon as that is then promulgated. Okay, I think I should stop there. I'm running out of breath now because Eugene is looking at me and then I'm getting more and more worried about time. We'll give an opportunity for questions a little bit later. Is that all right? Okay. Eugene?
Yes, there's just one thing that needs to be also said. There was no changes made to the inquiry system, the inquiries that women go to court. And we proposed that and we discussed that, and subsequently I've spoken to a couple of the stakeholders there as well. Some of that would be changed. Things that needs to be changed is the application form, for example, because that is a ridiculous form to fill in. It's not user-friendly. People don't understand that. That would be changed. One thing that they also never thought of was the criminality of the respondent coming there and giving false information as Section 6, because there's no measure that he could go there and be charged with perjury because the documents were not given under oath. So they're also looking into that. That was quite positive as well. Felicity asked if she can just have 3 minutes just to tie in with the NSP, just to round that off, and then we can proceed.
So in 2019, I wrote an email to the president, and I was raising whether maintenance and financial and economic abuse had actually been considered as part of gender-based violence. I sent the email at 12 o'clock. At 8:45, Dr. Olive Sasana phoned me and sent me a copy of the draft and asked me to make submissions from my perspective. I sat for 5 days going through the document, and while economic abuse, the common known or the better known form of economic abuse definition was included, in some of the impacts through the maintenance lens and the impacts of lack of financial support for children had not been addressed. So I made my submissions, and as a result, the use of maintenance as a form of gender-based violence was included in their definition. However, again, maintenance seems to have fallen down the order of priority or consideration within the GBV NSP. If we look at Pillar 3, which I sit under, and Pillar 5 is the economic pillar, Pillar 3 is the justice pillar. And how that became very evident to me is not just sitting on the pillars, but also at the DOJ workshop this week on the implementation of the amendments for the Domestic Violence Act. I had a conversation with a senior person within the DOJ who spoke over me when I was trying to establish why this has not been prioritized or included much. And she in fact said to me that use a Rule 58, use a Rule 43 to get emergency monetary relief in terms of maintenance. And I mean, I was horrified, because if you consider the amendments in the Maintenance Act, as well as I've been part of this process now since 2019. To hear that being told to me at a launch of the Domestic Violence Act amendments literally sent me into a state of panic. Over and above that, she actually said to me that this is not really, she didn't say it in so many words, but she was dismissive. And when I told her that I have a protection order post-marriage, she was actually quite astounded, because she could not conceptualize it in her head. And very soon I got to realize that she does not understand economic or financial abuse and the impacts thereof, and the intersections with physical abuse, sexual abuse. All the invisible forms of abuse are overlooked even in this amendment. I was unfortunately not there the previous day, and I'm going to go back and see if I can listen to it, because what is not understood is if they cannot see a visible form of harm, you have not been abused. And the invisible, silent forms of abuse are the ones that lead to the physical forms of abuse. If a woman cannot leave a relationship because of economic dependence, she stays, she gets raped in her marriage, in her relationships, she's abused physically, emotionally, and psychologically. So it is up to us to really become a lot more educated, to understand the impacts of this invisible, silent form of abuse and how maintenance is specifically used to continue harming the ex-partner at the expense of the children, and nobody is talking about that. So, I mean, it's very obvious that these informative lessons or workshops need to take place, and that I'm speaking to the converted here, I know that, but it needs to go out of part of organizations. Understanding the controlling, coercive behavior is critical in understanding not just economic and financial abuse, but sexual grooming as well. It's the behavior we really need to understand. These sex and money are just tools, because how do we change the trajectory if we do not understand this form of behavior? And at the end of it, one of my colleagues stood up, Caroline Peters, and she asked, how is this going to be implemented? When is it going to? When are the people on the ground going to be trained to be able to do this? And I mention this because, for example, there are still amendments that were made that were enacted in 2018 that are still not being used in the courts, right? Why? We cannot. One, we're running out of time. This has got to be positioned and pushed through the GBV NSP in terms of pushing it through Parliament, so we do not wait 5-10 years for any of these amendments. Every single stakeholder needs to position and lobby that this is dealt with the same urgency, because it is acknowledged in the definition of the GBV NSP. And we need to remind them, because if we don't, they're so busy trying to save women's physical bodies. They don't, I don't believe it's because they don't want to, we're in crisis. But this is part of the cog. Just wanted to bring it all together, because we cannot forget that for a moment. This needs to happen with the same urgency. Within a year, we need to see this now ready.
Right, thank you, Felicity. We all have our struggles with the acts not being properly enforced. It's like going to a brothel and the only thing that you get is a hug. The next one that we would like to introduce is Dion's boss. She is going to deal quickly with the recent case of Z versus Z. Just the award. Okay, so you're not going to deal with the whole case.
He did my case. He did my presentation.
Okay, so Dion alluded to that. So okay, she's going to do that then quickly. Natalie. Sorry. Oh.
Good morning, everybody. What an honor it is to do the most exciting part of the morning, I think, because gratitude is one of the wells that I live from. And so on behalf of the mothers from the maintenance courts who are launching a monthly award to maintenance officers across South Africa, this is a huge privilege. These incredibly strong and beautiful mothers have identified that a maintenance officer will be identified for the outstanding performance in their fulfillment of their daily duties within the maintenance courts, who play an active role in fighting for the rights and the justice of the future for our children, who recognize that each child has a name, a face, a belly, and a future, and not just a case number or another on the court roll. These staff members understand the acts, mindfully apply the laws of the acts, and use valuable knowledge obtained from their training. These are the people that will make a difference, who will always put the need of the child first, with dedication and passion in what can be seen as a harsh environment for all parties. Nelson Mandela once said, "Our children are the rock on which our future will be built. Our greatest asset as they are our greatest asset as a nation." Such wise and profound words. But what will be recognized today is not merely the words, but results achieved in these spaces. This is one of the things I love about these community dialogues, is that normal people, people of society, are all joining hands to fix a system that fails many. But in grace, we rise to help fix what the powers cannot fix. We do this for the future of our generations. I understand the heart of this initiative is to encourage, applaud, and recognize those with the power to change the status quo of the maintenance courts, who in this case is the maintenance officers. With this in mind, the mothers who started this beautiful initiative have called to the greatest South African moms to look for those golden nuggets of maintenance staff delivering excellent service beyond their call of duty. This award is in the form of a tree, which is symbolic for growth, love, and prosperity. Trees have a natural resilience, just like the many mothers sitting in the queues in the maintenance courts. The leaves of the tree each have a name of a child, collectively representing all children in the maintenance system. They wish to express gratitude to the first maintenance officer on whom this award is bestowed on. One of the moms mentioned that the leaves of the tree bring fresh oxygen to the environment they are placed in. So let's ensure this will also be the case here for our future. The winner of the first award is based in the Western Cape, where this staff member's dedication and hard work is applauded by all those that agreed that the first NPA Community Dialogue Award for Excellence goes to Roxanne Janssen. Just right here. Mrs. Janssen has prominently been mentioned in a few Facebook posts where members of the public announced there was a new maintenance officer appointed at Belleville Court who has no tolerance for cunning fathers trying to invade their maintenance duties. Within a short period of time, Mrs. Roxanne Janssen made it known to fathers in the Belleville cluster that there is a new sheriff in town. Well done. Mrs. Roxanne Janssen, the mother of Belleville, Cape Town, sorry, not the mother, but you are, thank you. Mrs. Roxanne Janssen, the mothers of Belleville, Cape Town, the Western Cape, and South Africa salute you for your hard work and dedication to ensure that children have a plate of food on the table. You are here to get your gift. Sorry, I'm just reading what the mom sent me. And finally, I'd like to read something one of the moms sent as well. The NPA Community Dialogue so far in Cape Town grows from strength to strength and has proven to be a huge success and a buzzword in the maintenance matters circles. Mothers leave these dialogues more confident, more knowledgeable, and with a glimmer of hope in their eyes. So a huge thank you to all who contribute and run this behind the scenes. Thank you so much.
Sure, this is such an honor and a privilege just to even stand here. When Advocate Ray just asked me to say something, I didn't expect that it would be something like this or even receiving something like this today, but it's a true honor. When you asked me to speak regarding the women and what they go through, I told him I cannot relate. I genuinely cannot relate what many of you have experienced because I was not at the receiving end of what you've experienced. But where I told him then where my passion stems from is from the children wanting to create change. I cannot change what happened in the past, but I can change from the minute they step into my office. I can change their future with what I know. And basically, what I try to live by is to give. Whether you step into my office just for advice, just for guidance, I'm going to give you something that hopefully ends in resolution. Your problem that you come with, I might not be able to help you with, but I'm going to direct you in a position where you can get help. So that is where my passion stems from, is to create change for the children. And that passion came from when I joined the Family Advocate's Office. And people look at me thinking, why would you leave the Family Advocate's Office, which is one of the elite offices, for a maintenance position? But it's the mindsets of people. They have this impression that they do not want to deal with conflict. Nobody wants to deal with someone else's conflict. But if I don't deal with the conflict, I'm not going to get to the resolution. So my mindset is, I'm going to go through it. I'm going to take the matter until the end, until I get a resolution for that child that is represented by the parties in front of me. Every day I do that. And yeah, so just one incident that I just want to share also. There was an interim order of a mother for 2 children. And the postponement was then done for the respondent to bring his documents. And on the documents, firstly, the applicant told me that she did not receive a last payment in respect of the interim order. And I saw that in his bank statement, he's got funds. And I allowed the matter to stand down, and I told him, I'm not dealing with this matter until you go to the bank, you draw that money, and you bring this children's money back to her. He did that, and we entered into a new agreement based on what came out of that mediation. So yeah, that's my stance. I will continue to fight for the rights of children in Bellville. That's the only area of jurisdiction, unfortunately. But yeah, that is my passion, and I'll continue to do what I
do. Well done, Ms. Roxanne Jansen. Thank you for doing the award. That's what we will try every month if there is one that is identified by the mothers. And it is not just going to be a Western Cape one. There are other golden nuggets all over South Africa, and we need to source them and make them known wherever they are. So we are going to start looking for those golden nuggets, and we will somehow award them, and we will applaud them for the wonderful work that they're doing. Ms. Roxanne Jansen is the first one. There will be more. And if it is that the award is going to be in somewhere else in South Africa, we will courier it, or not we, the NPA. I know the Postal Services guys here, so I've got some connections over here. I will see if I can get that couriered to whoever that maintenance officer is. So those that are online, if you have any case of any a maintenance officer or a maintenance clerk or a maintenance investigator that went beyond the call of their duty, whether it is that maintenance clerk sat with you after hours on a Saturday. I know of a few maintenance officers in the Western Cape, in Hermanus. Mr. Zweni sits on a Saturday and he will sit and do his work. There is one in Oudtshoorn, Mr. Zamile Joni, excellent, beautiful friend of mine, that sits every Saturday and do his work. So I know of some of these people that are out there that are going beyond the call of their duty. And it is for us to identify them. And it's not that all, it's a minority that somehow don't do their work. And because of that's why the Facebook groups of Felicity as well as Eugene is looking the way. So let's change that narrative. And we change the narrative to applaud those ones that go out of their way. And hopefully if they see that what Ms. Jansen is doing, then that will be replicated not just in the Western Cape, but all over South Africa, and that's what we want to achieve. Because if we get that right, then there will be more and more mothers that will get the services that they need. So once again, Ms. Roxanne Jansen, well done. You are the first. And I hope that it won't somehow stop you from also hopefully getting it in the future. If there's nobody else, we can our whole house can hang full of those trees and make sure that the house or the office, there's one for the house and one for the office. We can also arrange that. I also know of other things that Ms. Jansen, as well as her husband, is doing behind the scenes that I don't want to mention here. So a little bit private, what they are doing for other children, except their own children. So I know of people and what they are doing. And if we can somehow make these people known, then that's what we're going to do. I did ask my wife to do a presentation on the Z versus Z case, but we are seriously running out of time, and our presentation will take 45 minutes. So I asked that it stand over till September. So in September, she will do the presentation on the position of 18-year-olds in more detail, referring to the Percy versus Percy case, as well as the Butch or the other cases that are involved in Smith versus Smith and the other cases, as well as she will give recommendations on what women can do in order to oppose that application whenever they would like to oppose the application. What we will do now is we're going to have a short break of, let's make it 10 minutes, just for you to have another cup of coffee or to go to the loo. And then by the next 10 minutes, we will start with the National Credit Bureau that will do their presentation. The presentation will be plus minus 50 minutes to an hour. And then after that, then Eugene will do his presentation on spousal maintenance, and then Felicity will do the women's dialogue. So the break will be 10 minutes from now. So please, you can have some coffee up there, or you can go buy yourself some scones. had coffee in the auditorium and didn't pay for it, or that took coffee over the without going to Fabian. Can I just see how many people it is? Thank you, thank you. One. How many people had coffee over the in the cafeteria, and I don't want to say didn't pay for it. I just need to know how many people were there. You paid because there's a request that those people just pay the $10 for it. I will go and pay it. I just need to know how many people. So it's if you forgot, just put up your hand. It doesn't matter. Then I know how many I need to reimburse. One, two, two, two. So it's 3 people. Okay, so it's four. Okay, I'll just go and pay an amount. But I will get some milk and some sugar over there at the back so that those people that still want to have some coffee or tea can have it over there at the back. We are having problems with the data projector not screening on the wall. Those of you that have your phones over here, you can log on to the www.childmaintenance.org website and go click on live stream. Then you'll be able to see the presentations that we have over here. So despite that we can't see it over here, you can always follow on your phone, www.childmaintenance.org.za. Click on live stream, then you'll be able to do it. Those of you that don't have data, here are the Wi-Fi code. I'm not sure if they will be able to accommodate all of us, but I will keep it up here in front. So those of you that would like to go online can then use the Wi-Fi code. What I'll do is just take a picture of it. I'm going to stand over here. Those of you that want to go on the Wi-Fi code, this is the Wi-Fi code. Okay, so the next presentation will be by the Consumer Profile Bureau. The Consumer Profile Bureau will then have a talk. Who's going to talk first? Laurie, you will introduce them, and then I'll give over. You'll have to come and whistle again, and then they will listen. Thank you.
If you log on, just put your phone on silent, the sound silent, otherwise we have a bad feed. The sound like crazy.
Ready? Good morning, everyone. once again, thank you for the opportunity to address you today. My name is Laurie Gravenstein. I've been involved with the Justice Department for 25 years as a maintenance officer, a public. For the last 16 years, I've been involved in alternative dispute resolution, mediation most of the time. It started out with mediating maintenance disputes, and after 16 years, I'm still doing that. And I'm absolutely convinced that there's a place for ADR when we deal with maintenance disputes as well. So ADR, alternative dispute resolution, consists of a broad range of mechanisms to resolve conflict creatively and effectively. In other words, there's not only one way to skin a cat, there are many ways to skin a cat. There's not just one way to resolve a dispute, there are many ways to resolve disputes. And that will include the following. You can take the law into your own hands. You can litigate, in other words, take the other person to court. You can mediate. You can participate in a process of conciliation and even dialogue. So dialogue is the starting point of a conversation where we listen to the other person and we show to the other person that we are really interested in what he or she is saying. And by doing that, we gain trust and we create a platform for people to participate in a discussion to enable you to resolve disputes. I'm going to introduce you to 3 people who have worked very hard, but there's another one as well. Anneke Gravenstein sitting at the back. She's put everything together. She has worked relentlessly over many years to bring some of this work together. Although she's not speaking today, she has created this platform. I will introduce you to Mrs. Marina Short. She is the CEO of CPB, a credit bureau, one of the 5 big credit bureaus of a number of 48 credit bureaus. As well as Mr. Kobisa Sakwe, who is a director at CPB, and they will speak to you about credit bureaus. They will give you an overview. CPB's role in this process of dealing with maintenance matters as well as the role of the NCA, the National Credit Act, the National Credit Regulator, the Maintenance Act, as well as the POPI Act. And they will also assist with some questions on these topics. Thereafter, Mr. Nathan Eagles, he's our IT specialist, will take over and he will introduce to you an online portal that you can make use of to further your services in terms of maintenance orders, maintenance judgments, and so on, in terms of the National Credit Act. So briefly, what it entails the following. If someone has a maintenance order, so what we're creating here is, if you apply for credit, your maintenance order will show. Okay? I've been working with maintenance cases for the last 35 years. And I can tell you, even after 35 years, it's still happening at court. The guy comes to court, he says, I can't afford to pay that. Why? Because I've got so much debt. And because of those debts, I cannot pay maintenance. I dealt with a case this week. R60,000 a month. He's paying for the 3 children together 4,000 rand a month. Okay? He says, I'm so sorry, I can't afford anything more. I've got too much debt, etc., etc. Okay, can you see where I'm going? There's much logic in what we're doing, and it will definitely be helping the public. The second part is, when someone is in arrears with his maintenance, we already have a court order. That person is in default, and in terms of legislation, automatically the person in whose favor the maintenance order is made is placed in the same position as a civil creditor with a default judgment against the non-payer. You don't have to go through all the motions again. That's in brief. Mrs. Marina Short, would you please come to the fore, as well as Mr. Kuvisa Sakwe? After them, Mr. Nathan Eagles will take over. Let's give them a hand, all the way from Johannesburg. Thank you.
Good morning, ladies and gentlemen. I think I stand before you today, firstly as a mother and as a grandmother, and I've got 3 beautiful boys and I've got 3 beautiful grandchildren, and my biggest achievement in life is my children and my grandchildren. If I knew it was so nice to have grandchildren, I would have had them first, but then I got issued 3 boys, and I think because of that, this is something that's very close to my heart. And I've pledged as a credit bureau that I want to be involved with this. It's not been done yet, and I want to make a difference, and that's why we're here today. So proud to be here, and Laurie and Annika, thank you for reaching up. They asked me to speak up a little bit, so I'll try my best. If we look at, and Laurie made a comment about credit bureaus in South Africa. I think we're the country with the most credit bureaus in the world. We've got 48 credit bureaus, of which you've got different types of credit bureaus. We've got what we call full payment profile credit bureaus, which there is 5. A 6th one has come online, but they're not active yet. We've got niche bureaus, and we've got reseller credit bureaus. So you need to know about the main payment profile bureaus. By show of hands, who's looked at their own credit report in the last month? Okay. You guys know about all the data breaches that happened in South Africa. I can promise you your data has been breached. I can promise you. The only way you can see that is if you check your credit report. Is there transactions or inquiries being done on your credit report? So I would like to invite you to go onto www.myfreecreditreport.co.za. Go and have a look at what's going on your credit report. So just as a starting point, and no matter how many times you access it, it won't impact your credit score, and you can do it every day if you want. We're not going to charge you for it. So I invite you all to please go there. So I represent 3 credit bureaus: Consumer Profile Bureau, Crosscheck, and Medical Credit Watch. The other 2 are niche bureaus. But I think it's important to understand that if you want to look at a person's credit profile, you need to go to one of the 5 credit bureaus. So what is a credit bureau? A credit bureau is a place where we aggregate data that's voluntarily submitted or by law the National Credit Act says the data must be submitted. Sorry, there's an echo. Somebody's got the sound on. Okay. That you have to submit the data into the Bureau. We're one of the few countries that's got a very rich credit bureau data set, positive data and negative data. So positive, how well you're paying, negative, how bad you're paying, but also what is your obligations. And I think that's very important to understand what we do in a bureau. So a bureau is not a place where we blacklist you. A bureau is not a place where we decline you for credit. A bureau is a place where data is aggregated, it's then compiled, and it's actually given out for a specific purpose. I think it's very important to understand how that is going to work. The challenge with some of the data in a bureau is that they're not complete. Laurie was talking about the National Credit Act making specific provision that you've got to check it. But if I have to put it in layman's terms, when you apply for something, any credit or application that you want to do, the other person must understand, can you afford to pay this back, and how well did you pay it back historically? Because you've got to establish the risk around that. And if I don't have the data, how am I going to know that person that applied is lying on it? So you authenticate or verify it at a bureau environment. That's why it's so important to have a complete data set when we start talking about the data, the bureau data that sits there. So who's CPB? Proudly female-headed, only main credit bureau, female-headed. Proudly South African credit bureau. We've got no international shareholders. Myself as a shareholder, Khubisa is representing our BEE shareholders, and we're here in South Africa to make a difference in South Africa. So that's what we are. 41 years old, second oldest credit bureau, and I hope that we can make a difference in this process. I think I want to, at this point, apologies, hand over to Khubisa and just take you a little bit through the National Credit Act, what it actually says around maintenance orders. And I think it's very important to understand that although the Act makes provision for this, it's currently not being done. So we are here, we're putting our hand up and saying, we want to take hands with Anneke, with every person here, Laurie, the NPA, how do we get that information so that we can have a proper data set to get insight? So Khubisa.
Okay, I'm not sure if it's still the morning or it's afternoon, but good day everyone. So I'm just gonna continue where Marina has left off. In fact, what we're gonna do, we're gonna sort of do an interactive presentation. She started with the first part, and I'm gonna jump in, and then she's gonna interact with everyone. So if maybe anyone wants to ask a question, if you don't want to write it down, you can ask as we present. So the reason why we are here today, we just want to, probably something that you already know, but we feel like, it's important that you also hear it from our side as the Credit Bureau, the relationship between the National Credit Act and the Maintenance Act. We're not saying that maybe it's probably not public knowledge or maybe not everybody knows it. So the National Credit Act 34 of 2005, it requires the credit providers, be it your MTN, Vodacom, the West Bank, or West Bank, or whoever that grants credit, it requires them to conduct an affordability assessment on a consumer before granting credit to those consumers. If I show up at FNB, I want a loan, they can't just give it to me because I'm saying that this is what I'm getting. They need to do an affordability assessment. And if they don't do that, a credit that they've advanced can be deemed, or it will be said that it is a reckless lending. So if that person goes to court saying that they didn't require this information from me, so even if you gave them R1 million, if you were reckless when you were granting it, then it will be written off. So it will be your loss as a credit provider. Now, the consequences of providing credit recklessly would result in forfeiture of a loan amount, as I just explained, and the regulator is very, very strict when it comes to reckless lending, to the extent that the tribunal of the National Credit Regulator can actually fine that credit provider up to 10 million rand or 1% of their annual revenue, depending on which one is the highest. So, so it's very, very important that everything that you get as a credit, it must reflect in your credit information. So, the prevention of reckless credit, it says the credit provider must not enter into a credit agreement without first taking reasonable steps. And then the proposed consumer steps that must be taken, you have debt repayment history of that particular individual or of that consumer that you want to do business with or that you are granting credit to. Look at the existing financial means and prospect obligations of that person. What is this person doing with the money that he's getting? Now, in the obligations must include maintenance obligations, which is why we are standing here. So, in most instances where people are applying for credit, even if a person is paying maintenance, they don't disclose it or they don't declare that I'm paying maintenance. And as a result, a bank or a credit provider would give you credit without knowing that you have this. And the reason for that is simple. It's because there is no data that is reported or maybe that is reflecting on the credit bureaus. Now, that's why we're saying that now this now forms part of the relationship between maintenance as well as this side, because that information needs to be fed in there. So the criteria to conduct affordability assessment, sorry, let's just skip something. And then, the credit provider must enter into an agreement with having taken reasonable steps to assess the proposed consumers. Then also when conducting the affordability assessment, credit provider must calculate the consumer's discretionary income. And then B, it must take into account all monthly debt repayment obligations in terms of credit agreements as reflected on the consumer credit profile held by a registered credit bureau. And then I think Lori, when he was doing an introduction earlier, he touched on a person that earned about 60,000 by paying a certain amount for up to 3 children. And the reason why that is happening is because that part of due diligence is not done properly. Somebody goes there driving a big car with a wheel at the back and then only paying 300 rands or not paying anything at all towards the children. And then when they say that they are overcommitted, they are paying this, they are forgetting that the children that they're supposed to maintain should form part of those expenses. I mean, I can't be paying a car for 25,000 rands per month, but I can't even send my child to a school where I'll pay 500 rands. So it simply means that there's something wrong with the society, that, you know, you have to align your expenses together with what you pay towards your children or maintenance. So it has to be taken into account the maintenance obligations and other necessary expenses. So the credit providers are obligated to verify the information supplied by the consumer against the records held by the credit bureau. This information retention schedule, has no prescription period when it comes to maintenance. In other instances, maybe they would say that if like you are listed for a default, it will be there for 2 years or maybe up until you pay it. But in this particular instance, for as long as that child is dependent on you, whether he's 18 or he's above, then it remains part of your obligations or of your credit. So it is clear that the National Credit Act, which is what regulates the credit bureaus, expects the credit bureaus to display the existence of maintenance orders. But the problem that we have as the bureaus is that we're unable to obtain that particular information. And the matter is further complicated by the complex of the process around maintenance orders, number one. Then also there's various processes and there's various courts that need to be obtained. So without that information, it makes it difficult for us to actually keep it there. And we believe that if that information can be there, it would make things very, very easy for anybody that does maintenance, because you don't have to rely on my bank statement that I can simply go and open a time bank account when I know that, okay, in 3 months I have a court date. So I have to produce a bank statement. I simply just get a statement where I'm putting 300 per month, but I'm not giving you my Investec account. And unfortunately, from what I understand, is that even if that doesn't happen, you can't go and say, okay, bring all your accounts, because you don't know. I said, no, this is my only bank account. Now we have also, as CPB or Consumer Profile Bureau, identified some of the challenges that we believe that during the maintenance process, this is what the maintenance officers or prosecutors come across. One is the tracking of respondents. And we're saying under that tracking of respondents, you have a challenge with incomplete data. And some of that incomplete data could be, but not limited to what I'm going to say. It can be name, surname, or date of birth, or you do not have an ID number of that person. Maybe all you know is that the person is Tobisa Sako, but you don't know anything else. Or maybe if, like, you met me driving a Polo, you were driving a Polo with a registration number that is KG59GP, that's it. And as a person that's doing the investigation or that's doing the maintenance order, you don't know how to move from there because we have such limited information. And also, the identity information that you have, maybe you only know my date of birth and the year that I was born, and you only know the names, nothing else. So as a bureau, then we know that that is a challenge that is there. Then also there's an issue of conductability. And then under conductability, you do not know the person's telephone number because people change numbers all the time. They go to these small shops that don't even do RECA, then they buy SIM cards. Some people call them my friend, I don't know. You get a SIM card, you don't have that information. Somebody knows that, okay, no, this person has this number, but I don't know where this number belongs. So maybe the number is a work number, you don't know which company is it, or you were given a home telephone number, you don't know who is the person that is registered under that number. You don't have email addresses, you don't have their physical addresses, you don't have postal addresses, you don't have work addresses. Like a simple example, in one of the companies that you are assisting with what is called KYC, know your customer. It was a bank that is in the rural KZN. They don't have formal addresses. So all that is they will say, okay, Laurie Kleinfenstein, his address, I don't know his address, but he says he lives near a church. That's all you know. How many churches are out there, Or maybe he says, no, this person lives near a hostel. So now that's where we come in. But Marina is going to talk more about how we can assist, but we're just highlighting the things that we believe that are a challenge. And then also, you've met me maybe at a club, and then one thing led to the next, and then after that, you don't know who my friends are. You don't know who my family is. So you don't have any information on related parties or associates, or maybe I said, no, I'm doing business. This is my company. You don't know anybody else. You get there, no, we've never heard of that person. like I said, you don't have you don't have the person's relatives. You don't know if maybe I said I work for the NPA. You don't know who my co-workers are or which department I work in at the NPA. Then, most importantly, if I said that I work in construction, you don't have any other way of finding other income sources of this person that like you have a case against. You have very, very limited information when it comes to that. And this also includes SASSA grant recipients. Then you don't have information to trust, because a lot of people, they have businesses, but you will never find anything under their name because they are hiding behind the trust. That's information that you have. And you don't have any information when it comes to financials of the person. Also, even that information, it goes with what we call an income estimator. This person says, "No, I'm only getting 5,000," but you don't know what else you can get behind. Then you come back and say, like I think it was the lady who won an award here was saying that, you know what, when she went through the bank statement, then she discovered that actually this person has money. So that information, you can actually get that income estimation without even having to request a bank statement. Then there's credit reports. Credit reports, Marina mentioned that, you know, credit bureaus are not only about adverse records, because I don't like to use the word blacklisting because people think that maybe it's something so bad. And so because then the adverse record can be positive or adverse, or which is negative. Then you also don't know whether the person has judgments against his name, and even if a person said no, this is not my bank account, we can also go to the extent of going to say we're actually verifying the bank account if it actually belongs to the person, because people these days, they can even fake bank statements. Where we come from in Johannesburg, in Hillbrow, you can come up with a payslip, bank statement, proof of payment for just 200 rands in less than 5 minutes. So those things, if you don't have anything to verify whether they are authentic or not, then you will always have issues when it comes to that. And then that also goes with investments and other person. And then also there's assets, part of it. The vehicle ownership, I think I alluded to this earlier. Vehicle asset finance, insurance, those things are some of the things that can sort of help you to actually handle your cases correctly. And then property ownership, whether it's a stand or the person is an asset. No, I don't know his address, but at the gate it said R32. Then that's the only information that we have. Then we can assist in terms of getting what is the actual F number, where is this address, who does it belong to, purchase of data and price, current valuation of the property, the ownership of that property, whether the person is a tenant or maybe the person owns that particular property. Then it comes to business interests. And then on business interests, people dispute or deny that they have businesses, or they say no, they are businesses, they are not working. Then you should be able to tell whether that business is still registered or is deregistered. Then also people have medical aids, expensive medical aids, but they don't want to put their children under the medical aid. They said, no, I don't even have a medical aid. So that medical aid data can also help you in terms of actually saying, no, but you are paying so much towards medical aid and you have all your other children there, but not this particular one. So there's no fairness there. Then I think I've already spoken about the business interests and legal entities. Then we can also go to the verification of statutory information, individuals linked, past and current, auditors of the business, and whether the business or the person has judgments, as well as property ownerships. And I think from here, with what I've highlighted, I would like to invite Marina to sort of, elaborate more, and then maybe also advise us as to what difference can our credit bureau, together with social justice, fit and actually help to make your lives easier. Thank you.
And Fabisa is also a father to two beautiful daughters and a little boy, so it's always close to his heart as well. So how do we plan to make a difference? Annika and Laurie reached out to us and we decided we want to work with them. So the first priority for us would be, how do we get the data into the bureau environment? The Act makes provision for that, and with that I know that Nathan is actually going to take us through the app. I think it's going to take a tremendous effort, and everybody working together. Let's get the data into our bureau environment. I think the data that we need there's different data. Number one is a maintenance order. So that means there is an obligation to pay. It's similar to a credit agreement where you have a card. It's not necessarily the default, but it's the obligation that we need. And I know I read in some of the papers that people saying that obligations shouldn't be in a bureau. I believe it should be in a bureau. How else are you going to be able to do an affordability assessment as a credit provider if you don't know what the obligation is that sits in the bureau environment? It doesn't mean it's negative if there's a maintenance order, it's just the obligation. And I think it's going to be up to all of us to make sure that we don't label that as a negative, but an obligation, because that must be in the bureau. The National Credit Act is very, very specific on it, that must sit in the bureau environment. So how do we get that data in? Then the maintenance payment tracking. Is this person actually paying his maintenance? Because that's part of your obligations. And then when there is a default, how do we bring that into the bureau environment? So I think there's three parts to this. We need all three parts to be able to make an informed decision to be able to take this further. Once the data sits in a bureau environment, my board always calls me Mrs. Compliance, because at the bottom of all of this, I put the acts. So the first question is going to be, and we wanted to put a live demo out today, and I thought I'm not going to, because I have to consider protection of personal information. And what is the obligations for us to actually display that data? Is there proper consent in place? Is there a purpose in terms of the National Credit Act or the Maintenance Act? What data can I make available? To whom can I make it available? And how do I footprint this on my side? And how does this impact a credit report? So I think data aggregation first, then secondly, make sure the data is protected, and when can I give that data out? And we will be working with Laurie and Annika to make sure that whoever requests this data has got a valid request and there's a purpose, a prescribed purpose. What I can give back, sometimes it will just verify the information. We've got a direct link to Home Affairs where we can actually verify photo, biometric. There's a whole lot of things that we can do. Sometimes you'll just get the result back. The person says, my income is 20,000 Rand a month. We can verify that and says, yes, it's within the bracket. I don't have to provide back that his income is 21,320. So we can also do verification of that information. But it's important that we need a full view of this person so that we can assist you guys to make an informed decision. The other challenge we also have is track and trace. It's a general known in the market. But how do you take this little information that you have? You go and find the person. Once you find the person, you build a profile around him. Then you can actually understand to do it. So I think in track and trace, we are considering it will be made available via the app in certain formats. Important to understand what the compliance is behind that, but then also to the maintenance courts, because they will also have to assist in some instances with track and trace. So how do we make that available as well? Very critical is the training and the education during this process. How are we going to train and educate every single stakeholder in this process, from your applicant, your consumer, the mother, the father, the people working on an alternative dispute resolution, the maintenance court, and all of that. Very excited about the electronic serving of documents. We are working with another national project on that as well. And I believe that's the way that we need to do. your digital domicile sits on your phone. Nobody's going to a post office anymore. So how do we get that, and how do we make this industry a leading industry for this in South Africa? So I'm very excited about that. I think also what we want to bring in, how CPP is going to make a difference, and that's why I invite everybody to go and look at their credit reports. Nobody will know you looked at it. Don't be like an ostrich, put your hand in the sand and ignore it. It's not going to go away. How do we assist people with their own financial wealth and credit management? And then obviously, like I said, the free credit reports. If there's anybody, welcome to give my information and Gebisa's information. My email is marina@cpponline.co.za. We can make it available. If you've got queries, please, at any time, we'll assist with what we can assist. But we're very excited and we're very privileged to be part of this process, and let's make a difference. Are there any questions? Yes, ma'am.
Within the residential industry, you get a TPN credit bureau. As a private landlord, you can register with them and you can put on there whether your tenant is paying, is defaulting. Is that not something that we can do as mothers ourselves? Send our own maintenance orders somewhere where we can register, they can put it on, we don't have to rely on the maintenance system to do it for us? Because I'm sure all mothers out there will ensure that that maintenance order is registered on that credit bureau.
That is exactly what we're going to do with that. So we are looking at that. Laurie, you can answer as well. But definitely, so that's what I said. There's 3 parts to this data set. The number 1 is the order. The number 2 is the continuous payment. So you get that payment profile. And number 3 is when there's defaults. So that middle portion is very critical to do that. And definitely, we've put our hands up and we work very well with TPN. And they actually consume some of our data, and we've got integrations with them. But I think through what we're putting together, this is exactly what we want to build.
I do have one more question.
Go for it.
School fees.
Yeah.
Why is school fees not made its own thing on credit bureaus? Because so often, I mean, I used to do credit checks for a rental industry for many years, and never ever was there, this person owes school fees of 3,000 a month. Surely that is something that should be on a credit record.
Yeah, so unfortunately the National Credit Act talks about credit agreements. Now in some of the schools, it's private schools, it is seen as an incidental credit agreement, but there's no obligation. So when we had the discussions with Laurie and Annika, that is the important part. If a person is not obligated or forced by law to do something, it's not going to happen. That's why we're reaching out to the mothers and the fathers in some instances to help us to get this data. And we hope that the changes that's happening in the Maintenance Act, we will be able to enforce that data comes in. Schools is exactly the same. There is no obligation or law forcing that to happen. But how do we stand together and lobby and get that information in?
If there are men that are going out and buying new cars and buying new whatevers, and these companies aren't aware that they will have their own 3,000 rand school fees every single month.
But if we then get that into the maintenance payment system, then we will pick it up. You don't need it then from the school. It will then come in via the app and the mothers that we want to do. So it's always important to, and we've looked at the channels and the mechanisms, and we're all going to have to work together to get this thing properly done. From the courts, how do we get the orders in, the payments, the defaults, all of that. But from our side as a credit bureau, we said we put our hand up, we want to work with this process, and that's why we're here, also in our personal capacity today, because we want to make a difference, and we'll do whatever we need to do. At the end of the day, if you look at a person, you need to have a full picture of his income and expenses and his assets and his liabilities. And if we don't get the proper data sources together, then we can't do it, and then you guys can't make an informed decision.
Thank you. I would like to stop the questions there. If there are others that would like to ask questions, then what we can do is we can make another venue available, and then the other people that would like to ask questions can then go with Marina and with Tobani and then ask those questions. But we're going to be running out of time again, and to avoid that, it is just that I don't want to stop people. If there are people that are interested, which I like the questions that are being asked, then please, the two are over here. And there is venues on the first floor next to the security that I can open up, and then you can have your questions being answered by Marina as well as my colleague. Thank you so much, my brother, for coming. I'll give you an opportunity now, Eugene. What is important is that we get those orders to be registered with the credit bureaus. One way we can do it is, I know Laurie's got on his group, has got a place where you can make that available. Number two, your questions on school fees, make it part of your court order. Even if it's in the divorce order, that the divorce order says that he pays 100%, let it be reiterated in your divorce order. So when your divorce order goes to the credit bureau, that's how they can hold him liable. Even if it's 100% his responsibility, let it be made part of the order. It's the only way we're going to get beyond it. I just want to give over to Eugene, and then afterwards, then I'll take over. Nathan, sorry.
Yeah, maybe start with the name change. My name is Nathan. How's it? I'm Nathan Eagles. I'm the director of the business called Plum Systems, and we the technology development and deployment partner working with social justice. So I'm here to talk about, everybody's spoken about working together. So thank you very much to social justice for giving us the opportunity. But it's all about working together and bringing a whole lot of things together. So what we're developing, and in terms of, you spoke about a portal, you can actually go have a look at a website that's out there. It's existing already. It's called maintenanceorders.co.za. And you can actually go look at that. You can also, you're welcome to look at the slides. Unfortunately, we can't show it here now, but please do take the time afterwards to go through the slides and have a look. There's quite a bit of information in terms of what we're doing and how we're going to go about helping to solve the current challenges that we do have. Okay. So what is the process actually of what we're trying to achieve here? So if you look at the loan process that currently happens, is there's an application that gets filled in. That application is handed over to the institution. That institution would then go off to a credit bureau like CPB. And currently, as mentioned earlier, the maintenance orders or the maintenance detail don't exist. What we're building through this platform and this portal that we've developed with social justice is that people can go and upload their maintenance orders, right? And as part of that credit check that will now happen, we will make that data available via CPB, and that information will be fed back to the institution that's busy doing the credit check. So that's, and we'll give the information related to the actual maintenance order. So what's the amount that needs to be paid, plus arrears as well. So if there are arrears, we want to get into that position as well and provide that information. Now, why we all understand why we're doing this, right? It's all about helping children and making sure that maintenance is paid. Step one is really just decide to submit that information, and we can start here in terms of the portal that I've just spoken about, maintenanceorders.co.za. You can log in on that site, and there you can capture the data. So you can capture information about the person who's the maintenance order, both parties. You would capture information for both parties and also the children. And then you would also have the opportunity to upload the physical maintenance order. And we want to make it simple, right? Because on the day that it happens, that's probably the best time when you get that maintenance order to upload it. So we're looking at ways of how we're making it easier. Marina spoke about digitization of maintenance orders. That will be fantastic, because then we can build a link into that over time. But that's down the line. Hopefully not 4 to 8 years that was mentioned earlier, in terms of timing. But we do want to make it simple. So from an app perspective, allow people to take a picture of it and just upload it, right? Then what we will do, we need to confirm the accuracy of the data that's being captured, right? So it's not just a matter of You capture the data, you upload the maintenance order, and that's it. We will give both parties an opportunity to review that data as well, and we will do a validation. Compare what's been captured in terms of the data versus what is actually on the maintenance order. We will also send notifications to both parties. So when that data is captured, send of an email, send of an SMS. It's important that we get cell phone numbers, that we get email addresses, because then we will send a link out and say, here it is, this is what's been captured. Click on this link and either verify or comment on this in terms of the data that's been captured, whether it is valid. The other link over time that we need to think about as well is how do we get it from original source? Okay, so right now it's a matter of reliance on the parent to capture that data. Okay? We don't have that link just yet. And then that information, once it's been verified, once it's been approved by both parties, that data will then be available for any kind of credit check that then happens, right? And that process is really, that data for the maintenance order sits with social justice maintenance. Whenever there's a credit check, the process will be, as I mentioned earlier, the credit bureau would then request the information from us or from social justice maintenance, and that will then be fed back. So it'll go all the way through. So again, the importance and relevance of data is critical in terms of this process. Over time, what we're also building out in terms of is from a co-parenting perspective. There were questions earlier raised about those arrears. So we will help in terms of calculating that arrears. You know, what does it mean? How do you get to that arrears? We'll have the formulas and everything else built in there, get to the actual number and make that available. We will also be able to assist with the relationship with CPP around tracking, right? So if you need to find somebody, we would have that relationship and look at how do we get all relevant data and create that profile so that we can get access and help with tracking individuals. And then there's also the mediation that Laurie spoke about. You know, those kind of things, all the kind of things that we built in to the co-parenting capability and apps over time. And that's really just to help parents, help mothers specifically, and ultimately making sure that the results come through in terms of the children. So in terms of the overall process, there's a step-by-step guide that's available in terms of how do you go about capturing that data. And, you know, it's quite simple. We're trying to keep it simple. We're trying to make it as easy as possible. We don't want too complex processes. You just need to be able to access the website. And, yeah, that's basically about it. And like I said, the importance is we will provide the notification to both parties. We will do validation. And at the moment, manual process. But I think there's probably a huge need for it. See that? And I think probably, you know, between Laurie, them, and Anneke, I think they're going to have a hell of a lot of work coming their way soon, you know, in terms of having to help a number of parents. Sorry, Laurie, you were just talking about the app?
Yeah, I was just showing you, if you go to the maintenance orders.org.
You go into that website, maintenanceorders.org. It's live, it's there. The form is there for you to capture the details. You can do that now.
Go to start here.
That's right. You just click on the Start Here button right there on that very first landing page where you see it. There's a cool video there as well. I mean, it would be nice to show it earlier, but you can go to that website, look at that cool video. It tells you a bit about the story, and that's it. Okay. Are there any? Do you have a quick question?
Around education, how so parties are sitting there relying
please have a look at the video and then you give us feedback, in terms of if that is helping and setting the scene so that people do get informed. And that's what the video, it's a really cool video that Annika's put together for us, and I think it covers the most important points.
Just last month I mentioned about the uploading, but it wasn't last at the time. So is it live now? It's live now.
I'm just going to the shop to get a new SIM card just now.
So you from Plum?
Plum. Plum.
Plum Systems.
Like a plum.
So you software development.
Correct. I don't do it personally.
Okay.
If you ask me to develop the software, it's going to be a problem. So.
But you do that.
Yes, we have got a team that does the development.
Okay, sorry. The questions and wait afterwards, please. We've got some other people that also present. And apart from that, the reason why we stopped the questions is because if you sit at the back, the audio people, the people in the online viewers, I already had comments that they can't hear.
Okay.
So it's just a monologue between you and yourself, and because the people can't hear. Please, questions afterwards.
Cool. That's it. Is there anything else you maybe want to add, Laurie? You want to close out? We're good. Thank you very much.
Oh, so I don't have a lot. Right, so on we're still struggling with the technology side of things, and Dion has his laptop with the presentation that I was supposed to do, so I'm going to resort to the paper one. Right, so what I'm going to do is, and the reason why we included this today was that during the past couple of weeks, I've been inundated with queries from maintenance officers and queries from clients wanting to claim spousal maintenance, because that's also recognized by the Act, and they hear this all over and they don't understand that. Maintenance officers phoned me up and said, you know what, I have a lady that wants to claim for spousal maintenance. That's maintenance for a spouse. How do they proceed? They want to help these people, but they don't know how. My understanding was that the maintenance officers do not understand how the process of spousal maintenance work and how that relates to child maintenance in terms of a setting held at the maintenance court. So I'll be discussing briefly spousal maintenance, rehabilitative maintenance, token maintenance, and this just some forms of abuse that spouses experience after they have been divorced, relating specifically to a spousal maintenance. First of all, I need to tell you guys that there is a vast difference. You should differentiate and distinguish between child maintenance on the one side and spousal maintenance on the other side. Although it is maintenance, it is two different issues. Child maintenance speaks to, obviously, maintenance for the child, and spousal maintenance for the spouse. But there's a difference. If you look at the core of child maintenance is governed by the common law duty of support by the father, the biological father, to support his child. That is the common law duty of support of the father. And that is enforced by the maintenance courts. So if the father does not support, you can go to the maintenance court in order to enforce that legal obligation, that common law duty of support. But spousal maintenance, how can you be a spouse? You can only be a spouse if you are married. So you, as a mother of a child, not being married to the father cannot claim spousal maintenance. It is as simple as that. There should be a big difference between the two. Only if you are a spouse, if you're legally married, then you can claim spousal maintenance. Maintenance officers do not understand that, because the ladies come there and they say they need spousal maintenance. They've heard spousal maintenance and they want to claim spousal maintenance, even though they are not married. Now, there's a reciprocal duty of support between a husband and a wife if they are married. Husband has a duty to support his wife during the course of the marriage. That is one of the invariable consequences of a marriage. And that comes to an end when two things happen. Once the marriage terminates, or death. Those are the two things that would stop spousal maintenance. Now, the Divorce Act makes provision for certain court orders relating to maintenance and the divisions of assets, section 7.2 of that. And that could be reduced to a written consent of the parties. If there's no order for spousal maintenance, then the court may, in terms of section 2 of the Divorce Act, remember, you don't work with the Maintenance Act, you work with the Divorce Act. The divorce, section 7.2 of the Divorce Act then says that the court may, after taking into account certain factors, and I'll get to the factors later, make an order that the court deems fit for spousal maintenance. So the court can, on own accord, make such an order. It is an accepted principle in South African law that neither spouse has a definite right to spousal maintenance. It needs to be established and it needs to be proven in court. If you want to claim, if you're during the course of the marriage and you're busy with a divorce and you want to claim spousal maintenance, it's not an absolute right. You have to put evidence to the court in order to obtain an order for spousal maintenance. Now, because I said that there's one of the inevitable circumstances of a marriage which comes to an end, there is a reciprocal duty of support between a husband and a wife. It leads there to that once a divorce order has been granted, if the judge says, "Yet, ontslaaf van hom, God, you're not married anymore." Once the order of the divorce has been granted, decree of divorce, you cannot make an order for payment of maintenance after that. It needs to be dealt with as part of the divorce. Spousal maintenance equals divorce. Those two go hand in hand. Now, there's a couple of factors that the courts would look at. If there's no agreement, because the parties can come to an agreement to say, you know what, I'll pay you spousal maintenance for a certain period of time. And that would form part of the consent paper or the settlement agreement of the divorce order. But if there's no such an agreement, then the court may, out of own accord, make such an order if it feels that it is just and equitable. And in terms of section 2, there's a couple of factors that the court would look at. Number one, the means of the parties. That's now the means of the parties during the marriage. What was the earning capacity of the parties? Did the wife work? Was she forced to stay at home to look after the kids? All those factors regarding the earning capacity and the means of the people will be taken into consideration. The court is also very prone to use the clean break principle. You know what? You divorce, so get the hell out of each other's lives. Continue with your life. The courts regard, in most instances, and there's case law regarding that, as a husband and a wife's estates as two separate economic entities. And once they get married, it gets influenced together. But after they're separated and after they get divorced, those two economic entities should be separated. Unless, of course, there's children involved, because then child maintenance also comes to play, but we're dealing only now with spousal maintenance. The court would also look at the duration of the marriage. Obviously, the shorter the marriage, the less money you would probably get. The standard of living is also an important factor. The court would realize and recognize and investigate what was your standard of living. If you were accustomed to going overseas 7 times a year, going on expensive holidays, boat cruises, driving a very expensive car, the court would definitely take that into consideration as well when maintenance for the spouse is being considered. The court might also take into consideration conduct. Now, years back, we had a fault system or a different system that we have now. Nowadays, we have a no-fault system when it comes to divorce. There should not be a reason. Conduct should not play a definite role when it comes to divorce. Years back, we used the term in flagrante delicto. Oh, you had to catch him on the job. You had to have evidence and proof to court this is what happened, and that would suffice. Nowadays, we only have to prove to court that the marriage is irretrievably broken down. The courts nowadays, according to latest case law, appears to award little or no maintenance, spousal maintenance, when 1 or 2 of the following factors are present. Number 1, where the woman is still very young or reasonably young. Why would that be? The reason is simple, because then she still has the opportunity to go and look for work. She can still find employment and she can still earn something for later days. Where a woman is well qualified, the court looks at that as well. You would probably not get a lot of spousal maintenance. Where there's no children or no young children involved, the court would look into that. When she has worked throughout her married life, or is working at the time when she applies for the spousal maintenance, in all probability she will only be awarded a very little or small amount of spousal maintenance. The court will also look at her health. That also speaks to her earning capacity or the means that she could have in order to further the education later on. And also if the marriage was not very long. I said that previously. Like I mentioned, divorce is no longer based on matrimonial fault. Post-divorce maintenance or spousal maintenance is no longer considered as a penalty payment. Catching him on the job, he pays. No more, no more. So now we come to another portion, rehabilitative maintenance. So you've got the normal spousal maintenance, then you have rehabilitative maintenance. And that basically, in effect, means that maintenance is then awarded to a divorcing woman for a limited time, not forever, but for a limited time, to be trained or to be retrained in order to find a job or to continue with a profession. But that would also presuppose that she is able to be trained. Like I said previously, rehabilitative maintenance specifically is not a given. It is not a right. In terms of the case of Holzhausen versus Holzhausen, which is a 2018 case, the court held and said that spousal maintenance is not for the taking, but for the party who applies for it must show to the court that she needs it and that the husband has the means to pay that. That's important to know. Now we come to token maintenance. Remember I said you cannot claim spousal maintenance after the judge said, gone, you divorced. And you see the streamers and the bells and whistles and you go out for dinner and whatever, which is usually very, very unimpressive. Divorce courts are terrible. 3 minutes in and out. There's no streamers, there's no applause, there's nothing. There's nothing. It's just like, you know what, there you go, your separate ways. But things should happen there. If the court does not make an order for maintenance in the divorce court, spousal maintenance in the divorce court, you cannot claim afterwards. You cannot go to the magistrate court and say, but you know what, I've divorced this cheating person and now you want to claim maintenance. You will not be able to do that. So what the courts nowadays would do is, and I do it in my practice as well, say for instance there is a case that there is a risk that this poor lady that I'm acting on behalf might need maintenance in the future. I would ask the court to grant an order for token maintenance, the so-called R1 maintenance. And you get that. I put it in my divorce agreements and I said, you know what, you can pay, the husband can pay for the lady R1. She does not need to get the R1, but at least the door is open. The court made an order in terms of Section 7.2 and opens the door that she can claim spousal maintenance at a later stage. And then she can go to the maintenance court. Once that has been included in your divorce agreement, she can go to the maintenance court to say, but you know what, I need an increase for token. There is an order for maintenance. But if the court did not make an order for maintenance, for spousal maintenance, during the time of the divorce, you cannot claim for it afterwards. Maintenance offers as well. That's why they ask the people, you know what, we need a copy of your divorce decree. Because if the divorce decree does not stipulate that there's spousal maintenance payable in future, then you cannot claim that. Maintenance officer does not have the power. Maintenance court, being a creature of statute, cannot enforce or even make such an order after the divorce has been paid. I've seen many times as well where people want in their antenuptial contract, once they're starting off and they want to get married, then they sign an antenuptial contract being out of community with the accrual system, and then they want to include or exclude spousal maintenance later on should something happen upon termination of the marriage. That is also considered in terms of W versus H, a 2017 case. That's been said that it's against the community policy, contra bonus mores. It's not allowed. So the duration of this, how long? The duration. Let's talk about the duration. Now, the Divorce Act imposes no duration or no restrictions in respect of the duration thereof. The orders for spousal maintenance could be a fixed term, or it could be up until a certain time, or it could be absolutely unconditional. Where there's an agreement and it makes no stipulation concerning the duration, it seems that the maintenance obligation after death, or it continues up until after death. I'll explain to that in a moment. So when the court, if the court makes an order, remember now, you can in your settlement agreement, you can stipulate and you can come to an agreement on a certain period of time or up until a serious event happens, remarriage or death. If there's no such an agreement and it's only done by the court in terms of Section 7.2 of the Divorce Act, then in light of the common law, the payment will not normally continue beyond death. So it will stop when the debtor or the husband dies. If there's an agreement between the parties, then the courts would usually honor that agreement. And it is usually then that payment would continue until the death or the remarriage of the person who is to receive the spousal maintenance. When the agreement is silent, when there's no indication of duration, in terms of token maintenance, for example, we only give the R1 in order to keep it open, but there's no duration. There's no time linked to that. Then it would appear that the maintenance obligation continues after the death. It can still continue to after the death of the debtor. So what does the influence have of being remarried or of remarriage on the duration? If a person gets married again, remember I said that there is a reciprocal duty of support of spouses when they are married. So if you remarry now, then your new husband should look after you, shouldn't he? So then the previous guy is alleviated from his burden of paying spousal support. spousal support. So what happens during the divorce proceedings? Now, this is not all. I'm talking about claiming for interim spousal maintenance. So you are busy divorcing. It's acrimonious divorce, but you need money in the meanwhile. He kicked you out of the house, or he moved into with his girlfriend, and he's leaving you with the kids. So what can you do? You can apply to the court in terms of Rule 43 of the High Court or Rule 58 of the Regional Court for an interim order for spousal maintenance as well as child maintenance. It's done by way of application, so you have to submit your application to court. There's no oral evidence laid in most instances with regards to Rule 43 order. So now I'm talking about, yes, we're basically nearing the end. So what happens now? Now you have your spousal maintenance order, but you are still subject to some abuse afterwards from the father. What does that look like? And what is your remedies? Because remember now, the courts are very prone. They want the clean break principle. You go your way, I go my way, and it's two separate ways, and there you go. But there might be still a link towards with the children. That might still be, like Felicity always says, it's the glue that binds them still together afterwards. And that creates an opportunity for divorce, for abuse. So I'm just going to run through a couple of the abuses that we see quite often. Coercing the children to live with him to obtain child support from her. I've seen that now in parenting plans. I see that quite a lot where they say, you know what, no. I agree to a parenting plan, but the kiddies stay with you for 2 weeks and the kiddies stay with me for 2 weeks. So that means you pay for 2 weeks, I pay for 2 weeks. Then we quit. We don't pay maintenance to each other. No. You know what's that? That's a form of coercive and controlling behavior. Forcing her to borrow money from family and friends because he does not pay child maintenance. That happens. You have to incur debt in order to make ends meet at the end of the day. Again, coercive and controlling behavior, as well as economic abuse, which Felicity will speak about in a moment. Threatening to take her to court. Unfortunately, in South African law, and we are busy making proposals to the Law Reform Commission on that as well, to have systemic abuse also included as a form of domestic abuse. If he keeps you in court for days on end, forcing you to take off work, to spend your own money, to go sit at court for remandment after remandment, postponement after postponement, and he misuses the court system, that should also be considered abuse. That's not recognized at this stage in terms of the South African law. Blaming her for the children's financial hardship. Oh yes, we see that quite often. You know what, you don't provide. Or the other way around is also true, where he buys expensive gifts. Dad does not pay maintenance, but he buys all these expensive gifts. So that the mom, struggling, not getting any maintenance, looks bad. Isn't that a form of economical abuse or emotional abuse? Of course it is. Let me just see what next. I'm skipping some of these. Criticizing every purchase that she makes for the children. Why is it necessary that the kids needs that? Why did you buy that? Isn't that a form of emotional abuse as well? Of course it is. Purposefully using the court processes and procedures to exhaust your own savings or the mother's savings. It happens each and every day because inevitably the father is in a better financial position than the mother. So he uses that to his advantage. He gets 3 or 4 attorneys, advocates, the whole grocery list of legal representatives go to court, and the poor mother needs to dip and delve into her savings in order to fund that. And as we've heard, maintenance courts do not make orders or cost orders against fathers for vexatious proceedings. These are all just forms of abuse that you can find post-relationship or during the course of the after divorce. Using loopholes in legislation to protect assets. Fortunately, now in terms of the new amendment acts, creating trusts and loopholes in terms of living annuities, that has been stopped. Withholding some documentation, we see that quite often, and we see that specifically with regards to visitation rights, where you need to bring a children's court application because the father refuses to give you the passports of the children. We see that quite often. We see that quite often. So what are the remedies? Remember now, if you do get spousal maintenance, or even post-relationship or post-divorce, and you do not get spousal maintenance, and you feel that you are abused, then there is still a remedy. I found I had 3 clients come to me and say, but you know what, I did not know that I'm allowed to claim because we're separate. We're already divorced. So the people just say, but I'll just leave it. And she's still the subject of abuse. The Domestic Violence Act 116 of 98, together with the Domestic Violence Amendment Act 14 of 2021, recognizes the following as acts of domestic violence. Emotional, verbal, or psychological abuse. We all know that. Economic abuse, intimidation, harassment, coercive behavior, controlling behavior. To expose a child to domestic violence or an act of domestic violence. If the father does not pay maintenance, who suffers? It's a child that suffers. Is that child being exposed to an act of domestic violence? Of course it is. Of course. Can you make a case out that in order to get a protection order? Of course you could. And then lastly, the last act of domestic violence is any other behavior of an intimidating, threatening, abusive, degrading, offensive, or humiliating nature. Those are all acts of domestic violence that you can stand on and apply to court for a domestic violence interdict after your divorce has been granted. Thanks.
Thank you, Eugene, for the presentation on the different forms of spousal maintenance. So Felicity will be doing the next presentation on the women's dialogue. I think I can see the energy levels of people are also busy dwindling. So I still have a presentation that I have to do on school fees. I think we will have to let it stand over with the one on the Z versus Z dialogue, or the Z versus Z case, and the position as far as 18-year-olds is concerned, and then just deal with Felicity's presentation. For the month of August, we will have a female person that will be doing the presentation and the introduction of the speakers, as well as the whole presentation will be run and done by females. The only male that will also be speaking will be international in Spain, and that's the only other connection where we will allow somebody from outside to speak. But the local males, including myself and Laurie, we will not be speaking at next month on the 20th of August's presentation. So I'll hand over to Felicity and the presentation on the women's dialogue.
I can just move this one to the back a little bit.
tighten up the whole system. I think that's one thing. Yeah.
And then must we have this? Maybe that's. Sorry, we're trying to improvise. Eugene, do you want us to just, we're going to test that you can hear or that it's audible? Is it okay? So I thought that it would be appropriate to actually have a discussion with a victim survivor of economic and financial abuse, because it very seldom has a narrative, and people have a feeling that's uncomfortable, that they know it feels wrong and it feels abusive, but they don't have the language to articulate what that is. So I met Lanisa, and I walked in and she was standing in front of a notice board and she was speaking about economic abuse. And that's how we got to know each other. So I was incredibly proud that she had established that she was being abused and was wanting to speak about it and to make it more mainstream. So, and hindsight is always a perfect science, right? Yes, absolutely. So, you were married?
Yes. I was married twice.
To the same man?
Yeah, two different men. I was married. The first time I was married for 9 years.
Can you hear?
No, can't hear me.
You're going to have to do it.
Okay. My first marriage lasted 9 years. And then I was divorced for 6 years. And then I remarried. I was married for just under 3 years. My first marriage, I was really young when I got married. And so you start out, struggling with each other and those kind of things. So you don't actually see those red flags right from the beginning. But what I did realize was, like a few years into the marriage, you start feeling like you're going nowhere slowly, and you start wanting to grow and evolve. And so you have these conversations about furthering your education and growing in the financial sense, and so then what you must also remember is, I'm Muslim, and you have this whole stigma of these Muslim women that's supposed to be at home. So what happened with me was I was working in my family business, which was like a kind of safe thing, because so you're working with your mom and your dad and your brother and everyone around you. So that's okay, because you're just there. So then it would be like, I realized that I wanted more, and I felt that because he wasn't willing to grow, I thought, let me do it, for the sake of my family. So I applied to go and study further. And with that came a whole string of things. So it was like, but a woman's supposed to be at home. She's not supposed to be out there. But I felt that this is what I needed to do. And if he wasn't going to do it, then I needed to do it. But with doing that, it came with a sense of, so now you're more educated than me, so now you can tell me what to do. So you're more educated than me, so now you're wearing the pants. You're supposed to be the subservient wife, those kind of things. Those issues came up. Then, with studying, I needed to go and then work outside of my family business.
So when I started working outside the family business, it was like, oh, so who's this person? Oh, so then you start getting restricted in that way. You can't go and work because there's this guy and this person, and you've got this new circle of friends, and so those issues start coming up. But then what also happened was, so when it came to, so also because, like I said, because you're young, you have to start building up this credit record, and so you'll go like, okay, you open up those accounts, I'll buy the car, you know? So you think it makes sense at the time, like, let me deal with the little things and you go and you buy the big things, those kind of things. But when it came down to it, at the end of the marriage, it was, I was left with a debt and he left with the asset. So, you left on the back end. So all of those kind of things went down. When we initially got divorced, we had a civil agreement. Contract drawn up, this is what you'll pay monthly for the kids and for the school fees and all of those kind of things. And then I think 3 months after the marriage was dissolved, he decided he doesn't want to do this whole civil thing, right? Went back and forth, and eventually he just decided he no longer wants to pay. I waited patiently, when's the money coming, phone, didn't take my calls, and then eventually said, I'm not paying anymore. I was devastated because at that point it was still a struggle because I was studying. I was halfway in my family business still and sort of halfway trying to find myself in another company. So it was like trying to make my name, And then this comes along and it's like just like I felt like the rug was literally being pulled out under me. And my dad said, go to maintenance school. I was like, no, I'm not doing maintenance school. I don't, because also you must remember the stigma is that you want this man's money. That's all. When you mention maintenance school, it's about you wanting this man's money. It's not about the kids. You're either bitter or you're greedy or you're something, but it's never about the kids. So eventually I did go and I did an application. I first tried the mediation. I went to Advocate Abdurraouf at the time. And he said to me, he told me, look, I can mediate all I want, but if this guy decides he doesn't want to do it, he's not going to do it. There's nothing I can do about it. So I eventually went to maintenance school, did the application. I remember going in March 2011. My case was finalized in February 2012. And it was an endless stream of postponements, changing lawyers. It was, I think I could say I'm a fairly educated person. I would say that I'm a fairly mentally stable person. But I promise you, the process of going through that maintenance school broke me to a point where I didn't want to do it. I was financially, I was okay because, I had work. But even having that little bit made me want to say, I don't want to do this because of the amount of stress because you get there and nobody tells you this is what you need to do. Nobody explains this process to you. It's almost as if you've come here 100 times before and you need to know what you don't need to know what to do. Nobody explains anything to you. Nobody guides you. You're just given this form, stand in the line. No, you're in the wrong line. No, you're not supposed to be here. No, you're not supposed to come here today. You're supposed to be on Tuesday. So all these things. And also, if I didn't have, luckily for me, like I said, I worked in a family business, and then the other business that I worked in was also family orientated. If I didn't have that, I probably would have given up. Because the amount of time, besides the time that you take to sit in that court every day or whenever you need to go, the sort of how you need to build yourself back up after that day. It takes you another day to mentally gather yourself and say, okay, I'm ready to face the world now. So imagine going through that for an entire year. And it's not just going there. So when eventually we went to trial, and the questions that they ask you, like, why do you need 2 loaves of bread for the week? Like, why do you spend 200 Rand on toiletries? Like, I promise you, I asked the lawyer, I asked him, do you have a wife? He said, yes. I said, do you buy a sanitary towels? Do you ask her how much it costs? Because that's the questions that they ask you. And in between those things and the changing of lawyers and having to explain yourself every time a new lawyer is appointed, it is mentally devastating. So eventually, I came out on the other side, I got my court order, I won my case, I represented myself. And it was one of the most liberating feelings that I had after that year. Right? The year went by and everything went well until about a year and a half later, just decided, so my court order was for a monetary sum for each child every month, 100% of school fees, and they had to remain on his medical aid. After about a year and a half, school called me, school fees are not paid. I said, okay, and he just got married. He remarried about a year after that. And as soon as he got married again, school called me, school fees are not paid. I was like, okay, let me check. Sent a message, no response. I did get a response. I got a response in the terms of, what do you want from me? I'm married now, probably gonna have more kids, do your own thing, you must independent, blah, 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 all those kind of things. Next month again, school called, no fees are being paid, and then I started to get worried. So I go to court, I do the application, the years affidavit, everything is done. So I go through that whole process, right? Then he obviously then received the summons to say he must come back and appear for the arrears. As soon as he got that summons, I received an interdict. And the interdict read that I was harassing them and I'm abusing them and I'm abusing my children, and it was just a whole list of things going there. So then that ended up in appearing for the interdict, appearing with social workers, having home visits, and we're not even talking about literally the emotional and mental trauma that I had to go through, trying to explain to someone, but this is not true. So I had to go print all my SMSs, and that time it wasn't WhatsApp, it was little SMSs. To print all your SMSs, I had to prove my phone calls, I had to do all of those things, only to stand in front of a magistrate like 5 months later for them to tell you, can you guys just sort your crap out at home or something? So you go through that process, and then at the end of the day, you just get told, what, go home, and this is nonsense. Eventually, the arrears matter, we were on about 12,000 Rand arrears at that time. I went and I met a very good maintenance investigator, and he froze the bank account and he retrieved all the money. And so now we have to appear for the magistrate to hand over the money and for me to go and pay the school fees. And so on that day, the magistrate looks at the order and she says, well, this is not very black and white. I don't understand. She says, this 100% of school fees is a gray area. So Mr. Whoever, you will get your money back. Please make sure you pay the school fees. And she gives his money back. And so here I am, 11 years later, that amount times 100 because he didn't pay the school fees. For the next 5 years, he didn't pay the school fees. So when my children had to be transferred from that school to another school, I had to cough up 60,000 rand. I had to go make loans. Oh, wait, I'm skipping something. So in that time, he takes out loans, he opens up every possible retail account he can open up, he maxes out his credit card, and he goes to court and he says, I am under debt review now. I cannot pay my maintenance. I am reducing this application to 350 rand per child. Right? Maintenance, in fact, I was at Mitchell's Plain Court. Mitchell's Plain Court was so sick of this case that they transferred me to Athlone because they couldn't deal with it.
Cheers.
They transferred me to Athlone. It got to Athlone. Athlone didn't even look at my case. Athlone transferred me to Wynberg. I landed up in Wynberg Court. By the time I landed up in Wynberg Court, my arrears was now at 120,000. When I landed up in Wynberg, we went into, they said something about either it's a criminal case or a civil case, you can't have both, decide what you want to do. I then didn't want him to lose his job because his job required him to not have a criminal record. So I went for the civil route. He was supposed to sell the car and do this and do that and give me my money. I haven't seen a cent. I've been to Wynberg Court last year again. They don't even know where my file is. I'm not on the road. They can't tell me what's happening. It is just somewhere in the air, right? Anyway, so.
Okay, so when you like all these years later, when you look back at your marriage, do you see the pattern now? Do you see the abusive behavior that you were oblivious to back then?
I do. In my first marriage, it wasn't so visible. Because I think I was very naive at the time, and I think my need to be a good person kind of overtook my logic. So I didn't quite see things the way I was supposed to. When I got married the second time, though, it was very clear. So in my second marriage, it was, so the agreement was that he pays the rent of the house and, he pays for certain things and X, Y, and Z. So we had this agreement.
Was that when you first met? So these agreements made when you first met?
Yeah, yes, before we got married, because we signed a contract, right? Sure. So there was the certain agreements. You will make sure I am get this, that, and that, and you'll make sure that, I provided for all of those kind of things. And then when we got married, the first 2-3 months, it was like, oh, I can't make it this month, can you cover? So you go like, oh, okay, cover. And the second month comes, oh, I can't make it this month, I'll give you half, but can you cover the rest? And then after 3 months, it's just like, no, we don't even talk about the fact that you're not going to give me anything anymore, right? So you carry on and you carry on, and then it was a thing of also, so I had a car and he had a car, and it would be like, so I felt pregnant, and then, so you would be like, I don't think your car's like really safe for you to drive. Drive my car. I want you to be comfortable. You drive my car. So you think, like concern, all of those things. And then after a month, it was like, you're not driving your car. Why? Let's sell your car. Okay. So okay, let's sell the car. Sell the car. Maybe you can buy you a bit. You can save up and you can buy you a better one. And then after a month after selling the car, it was, oh, my car needs X, Y, and Z. Can we use that money in the meantime fix up this car, and maybe sell this car, and let's just buy us one big car for the whole family, you know, those kind of things. And then before you know it, you don't have a car, you don't have the money of the car either, and it's not coming back to you because you're busy doing your own thing on the other side. Also, like when you're working, like I had, at that point, I built myself to a point where I had my own private clients. I wasn't working, wasn't contracted to anyone. But then this one would be a problem, and then that client is a problem, and then that client is a problem, until you look around and you no longer have any clients because, you know, everyone is just a problem, you know. I got to a point where I was pregnant. My marriage was breaking down because of infidelity that I discovered. I had no clients, so I had no money. I had no car. I had no money. I had no clients, and I was stuck with this man because I was dependent on him because he constructed everything around taking away the little things that I had that kept me independent.
So was he married before?
He was married.
Did you ever speak to his first wife?
They were not very open to conversation.
Okay, but do you know anything about his previous marriage? Were there similar behaviors in his first marriage that you were aware of?
Not that I was aware of, because they were also very established women. And generally his family looked at, they were also fairly financially stable. But as in the marriage, you kind of figure out that, you know, like it's all this, I have this nice car, but
because with this kind of thing, the behavior doesn't just normally start developing.
Yeah.
Okay, the behavior is pre-existing.
Yes.
So this is what like now when you look back and you see that this was coercive behavior. He coerced you into swapping cars.
Yes.
He coerced you into selling your car.
Yes.
Okay. And then it becomes controlling because then it's like, sorry, I'm using the car today, you don't have access.
Yes.
So the controlling coercive behavior is probably what you felt was wrong, but you didn't understand it as being coercive and controlling.
Yes, yeah, I definitely did not see it in that way because, like I said, for me it was almost like concern. You want me to be comfortable, you know, those kind of things. So there will be a lot of like.
It's masked.
Yes, it's very. I can promise you, when you're on the outside, when you're looking back and I say it to you, you might see it immediately. But when you're in that moment, if you're in that situation, you don't see that at all. Like I said, it's not like I don't think I'm a stupid person.
But you see, so this, we kind of, and I mean, I often use like the analogy of the boiling frog.
Yeah.
Because the water is lukewarm when you get it, when the frog is put into the water. And then slowly, over a period of time, the temperature is increased. And the frog doesn't even realize that, you know, the water is getting warmer. And before the frog knows, he can't move because he's boiling. So that's very similar. That's what happens with coercive and controlling behavior, is it happens so sweetly and so subtly and so overtly that you kind of feel, well, it's masked with the caring.
Yes.
But looking back, you can see how one thing after the other created an absolute dependence on you. So my question to you was, from being so debilitated financially, how easy, did you end the relationship?
I did.
Okay. So how easy was it for you, under all of those circumstances, because you've now got kids from 2 marriages, to make that decision to walk out of this? And what prompted it? Was it because you thought, I can't let this continue, this looks familiar, a bit of familiarity from the previous relationship? You were a lot more familiar with, or the triggering, or the reminding that, hang on, I'm feeling this again, and I felt this before and it didn't end well?
I think it was literally, use the word, it was debilitating. I remember I was laying in bed one morning. I had a little baby, And if I must put you this picture, I'm an accountant, and 3 years prior to, or say 4 years prior to me ending that marriage, so before I got married, I was running, I had my private clients, I was running, I was consulting for a company where I was doing another 10 entities on itself. I had my own car, I had my own house, I had everything at my disposal, right? So for me, getting married was about having someone to share with, right? And the day I woke up that morning, I had nothing. I had the roof over my head, I had my house, but other than that, I had absolutely nothing. I did not have a cent on my name, literally did not have a cent on my name.
Did you have some debt from the previous marriage?
I had-
You were still paying off?
I had that debt, and then I had more debt because in this marriage now, they were my kids, his kids. You were trying to make things work. So I had, and also he then also went during our marriage, like shortly after we got married, he went under debt review. So I was the one stuck with everything. So my credit cards were maxed out. My retail accounts were maxed out. And I woke up this morning, had nothing to my name but debt. I didn't have any clients, I didn't have a job. I had a 5-month-old baby, 2 teenagers in my house, and I had nothing. And I realized that, then I sat and I thought, but this is what they want. They want me to come to them and ask them, can I have this? Can I have that? And I told myself, like, no.
So just when you were going through this first time and the second time, were the people around you? Did you speak to the people around you?
No.
You didn't?
No.
So I mean, do you think if you did, people would have understood that you were going through some kind of abuse?
I think at the back of my mind I knew, and that is why I didn't share it with anyone.
Why?
Because
Why
I knew
didn't you share?
that. Because I knew that if you see, I think I had a very people pleasing sort of behavior. So I knew that for me, and also and I'm gonna say this as a Muslim woman, you are ingrained in your brain that you need to be a good wife. And a good wife does everything, and she doesn't question her husband, and she will do what she needs to do to keep her house happy, right? So with the people pleasing and that in the back of your mind, you will do whatever you can, no matter who's going to tell you. If I was going to share with my friend, I'm giving this and I'm doing that, she'll look at me and she'll say, oh, you're nuts, you need to do that, you need to do that, and I'm going to be like, no, but I need to keep my children happy and I need to keep my home happy.
Was there some guilt and some shame? Was that part of why you didn't share it?
A lot. Because like I said, on the outside, I was this, to everyone, I got my things sorted out, like I'm very together. I would never let something like this happen to me.
A second time.
A second time, yes. And also the first time I never spoke about it. And so when it happened the second time, I was like, something must be wrong, and it was introspection because there's something clearly wrong with me.
So so you went through all of this, and was there any physical abuse with that?
Yes, it was. So that was also part of you not wanting to step wrong because you never know. So it was like you're waiting for them to walk through the door, and whatever mood is going to come with it, you need to just adapt.
So if you needed to go and buy something, now you're completely dependent on it, and you needed to buy something, you obviously could not bring up the conversation about money and your needs because there's this overwhelming, overlooming threat already, and that's part of the behavior, is to keep you submissive and oppressed so that you don't have to challenge their behavior. So when you look at the abuse that you experienced by the perpetrators, because there were 2 of them, and you are a victim of multiple forms of abuse, and if you then go to a system where you believe is going to help you, like you, the first time you went here, you probably went, ta-da, watch you, you silly bugger, I'm going to get you because I got the law on my side, here we come. And you were hopeful. And then it just like every time you appeared in court, it got bashed and removed. And so you had this shooting. In terms of just like comparing systemic abuse against the personal abuse, which do you feel was more violating for you?
Let me put it to you like this. I've got a 3-year-old now that I did not go and seek maintenance because of not wanting to go through, and not only not wanting to go through that process again, but for me, okay, so the other part of my second marriage was that after getting divorced, my 13-year-old came and she had a sexual assault charge against my ex-husband, her stepfather. So that added to a lot more, So it was that process that also needed to happen.
So you started fearing the courts, and now,
yeah, so because now
you don't want to go back.
So
do this irrespective of the more pressure economically and financially, but because of the systemic abuse and the violation, you're not prepared to go there. So did you go and seek counselling after all of this, or
I did
in terms, because there's a whole lot of this. One, there's the repetitiveness, and you wanting to be a people pleaser, using your own words, and there's all of this abuse, and then there's the systemic abuse that you don't want to make the same mistake again going into the next relationship, because if we don't deal with these things, we often then unconsciously just choose the same kind of person for the next relationship. Yes. And healing is so critically important to be able to deal with them, so that you're aware of these a lot sooner, and that you also don't put this onto your children, because this becomes the generational trauma that we've brought into. That's why we're people pleasers, and we make all of these compromises, and then we perpetuate this onto our children, and our girl children also become these kind of people. So we have the additional responsibility of breaking this generational trauma. And in that, again, yes, it's more work that we need to do, but we have to take that on, because if we don't, we're going to be sitting having the same conversations, watching these same patterns repeat themselves for ourselves and broadly around us. I want to just check to Haneen about, Haneen is a counsellor, because we often don't, we talk about the trauma. Haneen, please come and join us. Come on, sister. Is that, we talk about how we feel, all of us talk about how we feel going through the system, but how many of us actually go and try and get help so that we can heal? Because when we understand it and we become stronger, we can start going into these systems and we can hold them accountable. And we go, hang on, because you separate your personal experience from the systemic abuse. And then we can do them concurrently, because what Lemice has done out of fear, she's actually enabling a perpetrator to carry on his behavior and in his future relationships. And that's just additional responsibility for us, is to go, hang on, I will not allow you to continue being an abuser. And I'm going to use the system, and I'm going to hold the system accountable for doing what it's supposed to do to protect me. And I'm going to try and emotionally heal, and I'm going to work, and I'm going to wake up and go, hello life, I'm happy. Because we end up becoming miserable, and we're going to become sick, and we see illness, and we become short-tempered, and we see this level of aggression. So with all of this going on, it's a duty. We owe it to ourselves. It's not punishment, it's painful, but we actually owe it to ourselves to heal, because it's our birthright to have joy and happiness and functional, healthy relationships around us. Not so?
Correct.
So, I mean, you obviously see a lot of this. You're going to have to speak louder and come a bit closer to Amma, please. I would really like people to hear what you have to say.
Oh, I think actually that you and Lamisa did an amazing job. So I actually just want to say a little something. Lamisa and I come on a long way, and it's been quite a personal journey. So I was the counselor that she was referred to, at the time just after her divorce, and we walked with her daughter through the process of that sexual assault case. And that's going to be for her to disclose more of it. But so Lamisa is quite a champion, right? And she's got an amazing story to tell, and she tells it so well. The unfortunate thing is that hers is not the only story. And so in this crowd here that we are sitting, so many of us can put up our hands and say, I'm a victim of abuse. I'm a victim of domestic violence. And at the time when I was in it, I didn't know it, just like Lamisa. Right? And when we talk about gender-based violence and domestic violence and so on, then we go, poverty. But no, right? We are educated, we are qualified, we are professional, and we are in these relationships, and we don't know it. So we need to really start having these dialogues. And Felicity is so right when she talks about having to go and seek help, because it's not just that we perpetuate it. Really, the reality is that this is behavior we teach our children. Right? So it's learned behavior, and not just our girl children. I challenge you, really, check your boy children. Check your boy children, because the problem is not there giving awareness to your girl children. It is actually changing the narrative with your boy children. And so that's where we're going to change it. And that is where we're going to make a difference.
So can you just, for those that, realize that they need some help, if they haven't really got some kind of help? I mean, obviously, and I say this with all due respect, but going to get help is really for the economically privileged. If you have a medical aid, you can go and see a psychiatrist, psychologist, whatever counselor of your choice. But for the majority of the population don't have those resources. So this is not are there resources available for victims across the socioeconomic sectors, and what do they look like and how do they access those?
So I'm based at Athlone SAPS, and we run the Victim Empowerment Room. Every police station should have one of those. So if you have a mouth on you and you have something to say and you want to change the world, walk into your police station and ask how well equipped is your victim empowerment room, because these are services that we should give to people. When a woman, and I'm saying a woman because most applicants here, right, when we talk, they are women. So when a woman walks into the police station and she has a case like this, there should be immediate help for her. There is no reason why a woman who is fighting to get maintenance for her children, which by the way is the child's right, why are we still arguing this, right? So when a woman like that walks into the station, why does she have to come and pay someone like me for services? These services are available. Please, if you really go and hold your station commander accountable, these are processes and systems and services that need to be in place. It's free, it's part of the community service, it's part of visible policing, and they owe it to us.
Otherwise, ask out, ask out. Social media groups, find organizations, particularly that in the GBV space, who are active in communities, and ask them, are these psychosocial services or support available for your particular situation? There's a stigma attached to asking for help, or to, having all. Quite rightly so, it's 100th time you're telling the story, and every time you tell the story, it becomes, you relive it, but in spite of that, to get beyond that, we really need to be brave enough to say, I need help, I'm back there. Yeah. Because that's how we're going to heal, not just like ourselves, but that's also, that's restorative justice. Our perpetrators are also victims of generational and historic trauma. And while we don't excuse their behavior, we need to acknowledge that they are acting in a particular way because of something that happened to them. And we can hold them accountable, but we can also hold space and go, we recognize a repetitive, abusive pattern here, and hold space and encourage them also, because they're somebody's son, somebody's partner, and they might just become a father, and they're going to perpetuate it. So, for us to change the world, we need to change everything. We need to change. Legislation is not going to change the behavior, right?
So you actually use really important words here. Perpetrator, and because look, really, when a woman is when she's gone to maintenance court, essentially she's sitting in front of her perpetrator. Let's make no mistake. They've been through something. She has fear. And that is one thing Lamisa mentioned also. The fear. There's so much fear, the uncertainty. You don't know the law. You pretty much now have to learn the law. Because if you don't, so easily you could get messed over. So where we are now talking about somebody who essentially is a victim, right? And she now goes through this process. And she has to face her perpetrator over and over and over. And the system makes accommodation for that. Yeah. So I'm really excited when it comes to the online applications and so on, because that will take a lot of that away. There's a human element here that's getting missed. We are not looking at the trauma that people are facing. And constitutionally, it definitely is something, it needs to become more trauma-informed. But that's why we have all of you. So, yeah.
So, I thank you so much for being really, really brave and coming onto a public platform like this to share your story, because I think many people your story is their story, or parts of your story is the whole story or parts thereof. And every time we tell our story, we are one speaking on behalf of another victim, but we also giving another victim the courage to become a victim survivor. So thank you very much for being so brave. And thank you for coming to our workshops every week. And Honey, thank you so much for your contributions. I really appreciate it. Thank you.
Right, guys, that's it for today. Thank you so much all for attending. Thanks, John, and listen to you.
So before you all go, you're going to sing happy birthday to me. Because you're not going to be here. It's my birthday on Tuesday. Yeah. So before you all go, please sing happy birthday Happy birthday to you. Thank you. Happy birthday to you. Happy birthday to you. Thank you. I'm turning 60, so it's a big birthday. I make a noise about it because it's a big 60. So please allow me to be indulgent.
Okay, so I just want to give you the date for our next, you've heard it before, 20th of August. We will then be able to meet over here and make sure that we then have the Women's Day dialogue. All of you that have your name tags, please, there's a box over there as you will be leaving. Just put your name tags in there so that it's recyclable. We'll recycle it for next month. But thank you for coming. Those that are online, Liesel, thank you for all your hard work answering the questions online. Liesel Kanye was sick today, but she was online to be able to then participate in the process. Just want to also tell you the Sexual Offences Amendment Act is coming in operation tomorrow, the 31st of July. So there is exciting new amendments to the Sexual Offences Act that further regulate Section 54 as well as other provisions in the Sexual Offences Act. There's new definitions of sexual violation as well as the provisions as far as the mental capacity or mentally handicapped victims or survivors of sexual offences. Those of you that would like to get a copy of it, I will be able to make it available. The Sexual Offences Amendment Act that is coming in operation tomorrow. As from Monday, all of those sections will then be in operation. I've got a copy of the commencement of the Act. So please have a look out for that. Those of you that would like me to send a copy of the Government Gazette as well as the Sexual Offences Amendment Act, send me an email, dearitis@npa.gov.za, dearitis@npa.gov.za, and then we'll see one another